주요 쟁점 세미나 사회를 맡은 한국풍력산업협회 조국 실장입니다. 금일 세미나는 국제건설에너지법연구회와 저희 협회가 공동으로 주최하는 행사로서 제목 그대로 해상풍력 발전사업 추진 시 건설 관련 계약들에 대한 쟁점과 사례 등을 공유하기 위해 마련된 자리입니다. 먼저 금일 행사 프로그램에 대해서 간략히 말씀드리겠습니다. 한국풍력산업협회 최우진 대외협력 부회장님의 개회사를 시작으로 영국 CMS 런던 사무소 미즈사라 그랜펠님의 발표 및 이에 대한 토론이 진행될 예정이고요. 잠시 휴식 후에 법무법인 피터 앤 킴 한민호 변호사님의 발표 순서로 진행되겠습니다. 먼저 저희 협회 최우진 대외협력 부회장님께서 개회사를 해주시겠습니다. 네.
예, 안녕하십니까. 저는 한국풍력산업협회 대외협력 부회장을 맡고 있는 최우진입니다. 이렇게 자리가 꽉 찰 정도로 멀티 컨트랙팅과 관련된 이슈에 대해서 많이 관심을 가지고 계실지 몰랐고, 근데 아주 지금 시적절한 주제이고 논의라고 합니다. 이따가 이제 발표하고 토론을 하면서 다시 한번 말씀드리겠지만, 지금 해상풍력 사업이 분리발주로 가고 있고, 우리나라에서도 여기에는 근데 많은 사례가 없기 때문에 앞으로 많은 토론과 연구와 고민이 필요할 겁니다. 물론 이제 유럽이나 영국에서는 이미 멀티 컨트랙팅이 확고한 관행으로 자리를 잡았지만, 아직 우리나라 그리고 우리나라 기업들, 건설사들은 아직 익숙하지 않은 부분들이 많습니다. 그리고 법원의 판례나 판결례도 많지 않고요. 그래서 앞으로 이게 계약적인 부분이 해상풍력 사업을 물론 지금 우리나라에서 추진되고 있는 해상풍력 사업이 많은 어려움을 겪고 있습니다. 거기에 이제 가장 큰 어려움을 주는 과제는 이제 복잡한 인허가 절차와 주민 수용성 확보 문제인데요. 요게 이제 어떻게든 해결이 된다는 전제하에 정부 목표는 2030년까지 해상풍력 14.3기가와트를 설치를 하는 것을 목표로 하고 있습니다. 그 얘기는 1기가와트당 사업비가 6조라고 가정을 하면 2030년까지 84조 원의 계약이 체결이 되어야 합니다. 그래서 앞으로 해상풍력과 관련된 여러 가지 다양한 종류의 계약들, 그리고 계약 체결과 협상 과정에서, 그리고 계약 체결 후에 분쟁 관리 과정에서 앞으로 상당히 많은 그리고 집중적인 논의가 될 겁니다. 그래서 저희 한국풍력산업협회는 저희 존경하는 정 교수님과 함께 이런 자리를 통해서 이런 해상풍력의 계약과 관련된 이런 문제들에 대해서 공론화를 하고, 앞으로도 꾸준히 정기적으로 이런 자리를 마련을 하려고 합니다. 참석해 주셔서 감사합니다.
Well, good afternoon. It's a delight to be here today, so thank you for coming along. I also understand that typically these lectures are held in Korean, and I'm very grateful that you've allowed me to speak today in English. My Korean is not very good, so I think that you will enjoy this talk much more if I'm speaking to you in my native language. There's quite a lot to get through today. I'm going to be speaking to you for about 45 minutes to an hour, and then there's going to be a panel discussion. And so with regards to what I'm speaking to, I just want to give you a very brief introduction, and then I'll give you an overview of what I'll be speaking to, and then I'll get into the meat of today's discussion. So I've already been introduced. I'm a partner in London at CMS. CMS has over 70 offices worldwide, And we have a specialist team that deals with infrastructure, construction, and energy matters. And I deal with the dispute side of things. So in addition to helping clients in international arbitrations, I also provide project counsel or project advisory work, helping clients to avoid disputes. In the slide set that you've been given, and this will be sent around in soft copy afterwards, there are some details about CMS and what we do. I won't go through those today. I'm going to let you read those at a later time. So these are just some statistics for our year in 2022. We've got a pretty busy team. And this is just a map of where our offices are worldwide. So let me get into what I'm going to be speaking to today. The first two topics really are talking about the status of offshore wind projects. Where are we today? What are the targets? And what is this implementation gap that I'm going to be speaking to? And so that's really some scene setting, as I expect there's some very experienced practitioners in the room, but there may also be people here who are new to offshore wind. I'm then going to move on to some more practical examples and issues for discussion, which are very much through the legal lens, and that's going to be the multi-contract approach and why that causes potential issues or risks for you to be aware of when you are negotiating contracts or during project execution. The second is inherent risks in offshore projects. And I'm going to be speaking to seabed, weather, design, and supply chain, because those are what I see as being some of the key risks to be aware of when you are working on an offshore wind project. And lastly, I can't have a discussion today without speaking to you about disputes avoidance strategies, given that's very much my bread and butter. So I'd like to talk to you about how I would be approaching these sorts of projects and how I am approaching them for clients in order to help them to avoid disputes. And if you can't avoid disputes, to put yourself or your clients in the best possible position to win in an arbitration. So I've got some slides here that aren't in the slides that have been provided, but I just wanted to give a little bit of a visual feel for offshore wind projects. And this is the stages of a wind farm project. It's offshore. These are the 5 stages, and really, if you're talking about this from a legal perspective, planning and development is when you'll be negotiating the contract. And then the next 2 stages are when you've got project execution from a construction perspective. Now, the reason I've included this particular excerpt, which is from Ulstein's website, is because they are a Norwegian company that supplies vessels. And I thought it might be helpful to also see the range of vessels that are required in relation to an offshore wind project. And so you've got those listed under each of the separate stages. I'm going to come on to some of the challenges in the supply chain in relation to, are there enough vessels being built or in existence in order to meet the targets that countries and companies have set for themselves in the coming years. Now, just to speak a little bit here to installation targets, this is from a report that was published by the Global Wind Committee, GWEC, and this looks at 2022, so this is the year that we've just had, and so those are historical factual installation, and it's split between onshore and offshore. And then from 2023 onwards, it's anticipated build out or targets. I think what is helpful to see here is firstly that offshore wind actually makes up a reasonably small portion of overall wind that is being built out, but also that there are significant amounts of onshore wind that are being built. And so obviously there are going to be, there's going to be competing demands for some resources and materials for these sorts of projects. So when I talk about supply chain challenges in the offshore space, some of those will be unique to offshore, but some of them will also be supply chain risks that are shared with the onshore projects, particularly materials and components. You can also see here that what is being built out in 2022 in the offshore space is reasonably small compared to targets and what is needed to meet net zero targets. So maybe just to give a little bit more detail on this, for those of you who aren't familiar with the figures and what's actually required. When I read reports or what's in the news about what needs to be achieved in order to meet net zero targets in the offshore wind space, the language that I see is there is a gargantuan effort that is required, that there's going to be a massive expansion of the supply chain. In Europe, that's going to need to be more than triple what is currently being provided. To give you an idea of scale, by 2030, the target is that 380 gigawatts of offshore wind be implemented, be built, and 2,000 gigawatts by 2050. Now, at the moment, globally, the world is achieving around 20 gigawatts, and that was what was achieved in 2021, and that was the best year yet. Now, 80% of that was built out by China. If you look at what is needed in order to meet offshore wind targets, it's about 70 gigawatts per annum, year on year. That's what needs to be built out. So the challenge here is actually meeting these targets, and it's scaling up sufficiently in order to do this. And that is going to bring pressures on the sector to be able to have access to vessels, materials, workers who have the skills to complete these projects. Just to give you a little bit of an idea in relation to supply chain issues, I just wanted to hone in on the material breakdown for an offshore wind farm, just to give you a bit of a view on this. And so you can see here by tonnage that steel is overwhelmingly the material that is required mostly for building out an offshore wind farm. But you also have things such as copper, which is needed for cabling, and also rare earth minerals. And these are, so this is the split. And if you've been reading the news, you'll have seen that the price of steel has increased by more than 50%. The price of copper has increased by more than 60%. Rare earth minerals have more than trebled in cost. Now, part of this is due to geopolitical issues like the war in Ukraine, but part of this is also due to supply and demand. And so that is an issue that's going to continue or perhaps be exacerbated going forward. Now, the next two graphs I think are interesting because they show where many of the materials that are needed for offshore wind are being produced and processed, or mined and processed. So the table on the left, if you look at copper down to rare earths, if you see the turquoise colour on those bars, that represents China. So mostly it is China that is mining and processing materials that are needed for offshore wind farms. The graph that's on the right-hand side is taken from GWEC's 2023 report. And as you can see here, overwhelmingly, it is China that is mining and processing rare earth minerals, which are needed for offshore wind. So I will come on to these points a little bit more when I talk about supply chain challenges, but it's certainly something to be aware of when you are negotiating contracts or assessing risks on offshore wind projects. So before I move on, what I just wanted to let you know is that in my paper, I've relied upon certain resources. And if you have an interest in offshore wind, I would urge you to be looking at those resources. So the first is the GWEC report, which is produced annually. Mostly I've relied upon the 2022 report, but you might be delighted to hear that the 2023 report was published around 7 days ago. So I have taken account of that in my presentation today, but the paper that you will be reading is based upon the historical figures in the 2022 report. I'm also referring to a study that was undertaken by BVG Associates, and it was on behalf of the Scottish Offshore Wind Energy Council. Now, Scotland is well known for its experience in offshore wind and onshore wind, and it commissioned BVG Associates to undertake a study looking at contractual terms and conditions from the developer's perspective, from tier one contractors' perspective and from the smaller suppliers. This study very much chimes with my own experience. The reason I've referred to it in my discussion paper is because I think it's also a very helpful paper to review to see what sorts of challenges parties are facing, because you may find that you're facing them yourself, either if you're in-house yourself or if you're an external lawyer for your clients. So let me move on now to the multi-contract approach. So this is very much getting into the meat of today's discussion. And this is focusing on specific legal risks in the offshore wind space. So I mentioned the SAWEC study, the Scottish Offshore Wind Energy Council study, focusing on comments from tier one contractors, developers, etc. What they're really being asked is, how do you manage risk, and why is risk being managed in the way that it is being managed? And up on the slide here is a summary of the findings of that study. And I think the first point to make is not, it won't be news to you, but it's that risk is best managed by those with the skill and experience to manage a risk. And that's why ideally, when you're negotiating a contract, a particular risk will sit with the party best placed to manage that risk. But there's a big but here, and that is that risk allocation on offshore wind projects is driven by project financing and bank requirements. That was acknowledged in the SAWEC study. So developers were saying, although they recognise that risk is best managed by those with the skills and experience to manage specific risks, in fact, they are required to deliver a project that carries as little risk as possible. How is that achieved? It means that risk is being pushed down. So it's pushed down from developers to tier one contractors and suppliers. Tier one contractors and suppliers then push it down to the smaller suppliers. And that means that you're not always having risk sit with the party best placed to address it. Now, you might say, why does that matter? If I'm a tier one contractor and I've pushed all the risk down, why does that matter to me? I think the overall aim on a project is to deliver the project on time and on cost. And anyone who's been involved in construction, particularly offshore construction, knows that if something goes wrong, it can go badly wrong. It can lead to knock-on delays and significant additional time and cost. So if everyone wants to achieve the project on time and on cost, the best way of doing that is allocating risk appropriately. But what we're seeing with these sorts of projects is that's not always happening, mostly because of project financing requirements. The other thing to note is that developers contract directly with tier one contractors typically, and then suppliers in turn contract with the smaller subcontractors or suppliers. Developers are not, according to this study, seeking to influence the terms of those contracts further down the line. Now, what I think this can lead to is inconsistencies or gaps in contracts. Now, if I take an onshore project by way of comparison, an onshore project typically has full EPC wrap. So you'll have a developer or owner who contracts with a main contractor, the main EPC contractor, who is responsible for managing the subcontractors and delivering the project. And then there are a series of subcontracts that are, or packages that are subcontracted out. Now, if you contract in that way, it is much easier to ensure that there are not gaps between contracts, that you have provisions back to back between the contracts. But that is much more difficult when you have this multi-contract or disaggregated approach. I guess the final point I make here is that tier one contractors commented that they are being presented with heavily amended contracts, including irrelevant and disproportionate risks, which inevitably feeds down to the lower levels. So this is the approach that I'm talking about, where risk is being pushed down. Now, there's a couple of points just to make here. The first on heavily amending contracts. There are no standard forms that are being used in the offshore wind space that I'm aware of. But what we are typically seeing is that developers or owners are using FIDIC, Yellow or Silver Book. Those contracts are being heavily amended. Now, standard form contracts like the FIDIC suite of contracts are typically prepared in a way that allocates risk, hopefully proportionately between parties. if you heavily amend these contracts, you do face the risk of having gaps within the contract itself, but also placing risks on parties that are less able to manage them. And that's what the tier contractors have said. But the other thing is that if they are being heavily amended by one developer, but then heavily amended in a different way by a different developer, what tier one contractors are saying is that they're not seeing consistency. And that obviously requires a lot more work and analysis in reviewing these heavily amended contracts and identifying risks. So it just means more risks to work out, more work in the negotiation phase. The other point I wanted to make is that I've talked quite a bit about risk being pushed down to the smaller suppliers, but what I am seeing, so this is very much anecdotal, but what I am seeing is a bit of a shift, power play or the dynamics, the negotiation with smaller suppliers. And I think that is partly because of supply and demand. So if there is a real demand for a small supplier of a particular type of material, lots of projects where they might be required, and they also consider that they simply cannot agree to certain terms, I am seeing those smaller suppliers putting forward their standard terms and conditions. And often, I think what that is going to do is to put a lot of the risk on the tier one contractors. So there will be gaps, but also if a smaller supplier foresees, for example, some difficulties in the supply chain or increases in cost, and it thinks simply, I cannot deal with these risks, I am too small to do so, I would go under if I took on this risk. If they are saying to the tier one contractor, you can take my contract or leave it, and if less attention is being put on the negotiation of those sorts of contracts, which I'm also seeing, which my transactional colleagues are seeing, I think there's a real risk that the suppliers will have less risk placed with them in some circumstances and more risk with tier one contractors. So this multi-contract approach that I'm talking about, also referred to as the disaggregated approach, typically it's the developer or owner having an EPCI contract with the major components, with a contractor who can provide the major components, and then a series of smaller contracts with suppliers from the tier one contractors. Now that is due to project financing, as I said, but also simply because offshore construction projects are very risky. They carry with them a risk that specialist suppliers, for example, of turbines or cable laying contractors, are simply unable or unwilling to take on. Now, you might say perhaps this has some advantages, and I think potentially it does for the developer because they have greater freedom to manage the project and to choose the right suppliers of various components or parts of the works. And it may be that in doing so, they can exclude the cost that comes with the risk element in a typical onshore EPC contract. But perhaps this is me as a disputes lawyer, but I see the risks as being greater. Because actually, I think what it leads to is a patchwork of contracts across the whole project without having one party like the EPC full wrap contractor on an onshore project having visibility of all of those risks and being able to manage them better. So how do you address these sorts of risks? I don't think that there is an easy answer to that, but obviously the first step is during the negotiation phase to identify the risks, to see what you can seek to negotiate so it does not sit with you. Now, I am not the person who conducts negotiations. My transactional colleagues do that. But I do know that it is fanciful to assume that you can achieve in negotiation perfectly drafted clauses and an equal allocation of risks. It's simply not the way that contracts are negotiated. So the first step is to try and negotiate a position that is more advantageous to you, but recognizing that often that will not be possible. The second step is to identify the risks that sit with you and then to be alive to those and to seek to manage those through the project execution phase. And I'm going to speak more about how you can do that later on in the discussion. So I want to speak now about specific risks that I've identified with this disaggregated approach. And there are 8 issues that I'm going to speak to. I've got some time constraints today, so I'm not going to get into all of these with the same level of detail, but I would refer you to the paper that I've drafted and that's been circulated, which goes into more detail on each of these. So the first one is interface risk, or the risk of knock-on delays. Now, I think the first thing to be aware of is that in the offshore space, the impact of knock-on delays can be quite significant. What's an example of that? It may be that work that needs to be done by one tier 1 contractor before another contractor can do their package of work is delayed. So how is that dealt with? How is that interface dealt with? Now, those sorts of risks are typically managed through interface meetings between the tier 1 contractors. It means that they have to discuss their packages of work. They have to have a familiarity with each other's programs and the knock-on effect from one package of work to the other. There's also often an obligation on contractors to issue early warning notices when something goes wrong, so that everyone has familiarity or notice of that. There can be an obligation to feed into a risk matrix so that everyone's aware of what the risks are on the project. And it may be that there is a specific obligation on a contractor to look at programs that their other peer contractors have prepared and to comment on those if they think that they're not appropriate. The challenge that I see with these sorts of clauses is that they're often, I would say, woolly or sometimes difficult to apply in practice. And you'll also often see that contractors are seeking to do the work that sits with them and to manage the risks that sit with them. And so it would be, it's a difference between a collaborative approach on a project, which is more of a contract alliancing approach, or a protectionist approach. And that means that you're just trying to deliver what you need under the contract and to avoid there being any problems that sit with you. And I think historically, it's the protectionist approach that contractors take. Now, that's certainly not a criticism. I think it's just a reality. But I think the problem with these sorts of projects where you can have such significant consequences if one package is not delivered on time and it impacts another, parties working together to overcome these interface risks. If the mindset is this protectionist approach, I think often that is just going to create problems rather than help parties work together and resolve issues as they arise. The second point to talk about is liability gaps. Now, it's going to be important for parties to ensure that their potential liability or risk is proportionate to their reward. And so if your package of work is only 1 million, if you're a very small supplier, you're going to have to limit your liability so that you don't end up being on the hook for significantly more by way of loss and damage if things go wrong. You don't want that risk to sit with you. But the problem with the disaggregated approach is that this patchwork of contracts I was talking about is being entered into in stages. So I have seen, for example, smaller suppliers capping their liability so that they are only exposed to the value of their works. But the consequences of them not delivering on time could be significantly more than their exposure. Now, where will that risk sit? It will usually sit with the tier 1 contractor unless they've been able to negotiate good terms with the owner developer. And as I said before, that's not what I'm seeing. The Sowick study is saying that these risks are being pushed down. The other thing is that if you have lower liability caps and something goes wrong, in my experience, parties will look at their exposure, you look at your limitation of liability, and you make an assessment. Do we remain in breach of contract but do our best to deliver? Or do we incur additional time and costs that will sit with us, the breaching party, in order to try to mitigate delay or additional cost? Now, it would be a foolish party, I think, that would say, I will take on extra costs in order to overcome delay, reducing my profit or eroding my profit just to deliver the project on time. So sometimes these lower liability caps can have the consequence of having a party more comfortable with breaching the contract because they simply can't afford to take the steps to remedy the situation. Now, the third point I wanted to speak to is mutual hold harmless regimes. It is common for contracts concerning offshore oil and gas installations to operate on what's referred to as a mutual hold harmless or knock for knock basis. And what that means is that each party to the contract agrees to take responsibility for injury or damage to its own people and property. The reason that's been agreed for offshore oil and gas installations is because there's recognition that each party is best able to deal with risk if it's allocated in that way, but also because the cost consequences of damage to people or property in the offshore space can be very, very significant. Now, I'm not going to go into this too much because I'm conscious of time, but please do have a look at my discussion paper on this because there are some things to be aware of. Mutual hold harmless indemnities have been upheld under English law, but if you are contracting under a different law, you will need to check that those sorts of provisions are legal. You also need to check that they are truly mutual. So very much the English phrase is the devil is in the detail. So it's fine to say, well, we've got this provision, so we're safe. You need to read the terms of that clause and make sure it truly offers you the protection that you think that you have. Now, the fourth point I wanted to speak to in a little bit more detail is consequential loss exclusion clauses. These are used heavily in the energy, infrastructure, and construction sector. But I think that what an issue with consequential loss is that it's commonly not well understood. And that has caused a number of disputes. And it is also treated differently in different jurisdictions under different governing laws. Now, CMS has prepared an expert report, essentially, on consequential loss clauses in different jurisdictions around the world. So it's a comparative report. And I've got the link for that at the end of this slide. So I would urge you to have a look at that if you need to understand how consequential loss is construed or interpreted according to the governing law of your contract. But I just want to make you aware of a couple of points today. The meaning of consequential loss under English law, you may be aware, is not the natural and ordinary meaning of that phrase. So consequential means losses flowing from a particular event. But actually, the meaning of consequential loss is far narrower than that. And so I've got up on the slide here the types of loss that are recoverable under English law. And they're commonly referred to as the two limbs of Hadley and Baxendale. And that is the case that they're based upon. It's a very old case. Now, the first limb of losses is losses arising naturally according to the usual course of things from such breach of contract itself. The second limb is consequential loss, and this is the one that people struggle to understand. Now, I've got on the right-hand side a restatement of this limb under New York law, and I put it up there because I actually think it's much easier to understand. So it's losses following from the breach as a result of special circumstances beyond the ordinary course of events that the party in breach had reason to know. And if you know the facts of Hadley and Baxendale, it was essentially in relation to a crankshaft for, I think it was a mill, and it needed to be replaced, and it was asked to be replaced, I think, by the next day. And that didn't occur. It took a week for it to be replaced. And the owner of the mill sued for its losses for that period because it couldn't do any work, so it couldn't make any profit. And it was found that was not, the fact that the mill could not operate without a crankshaft was not known to the party who needed to provide the crankshaft. So if the owner of the mill had said, I don't have another crankshaft, I need this tomorrow. Do you agree to provide it tomorrow? If you don't provide it, I will not be able to operate my plant. Now, if that had been conveyed to the other party, that would be a consequential loss. But because that was not conveyed to the other party, it's a loss that's not recoverable. But hopefully you can see from that example that it is not the natural and ordinary meaning of that phrase. And so it's important to be aware of how consequential loss exclusion clauses operate, and also to be aware that heads of loss, for example, loss of profit, are not automatically direct losses or consequential losses. It depends upon the circumstances. So a misconception I often see is that loss of profit will be excluded if you exclude consequential loss. That's not necessarily the case. So it's something just to be aware of. The other point I just wanted to bring to your attention, and this is simply the comparative approach, is that consequential loss is not construed in the same way around the world. And if there is no given meaning at law, which is the case in many civil law jurisdictions, particularly in the Middle East, then it will fall to the arbitral tribunal or the court that's construing this clause to decide what consequential loss is. You might say, why is that important? What you don't want is downstream, or you want a contract with your supplier to exclude consequential loss under one governing law, and your contract upstream to exclude consequential loss on a different governing law, and for those to be construed as meaning different things. That's one reason. The other thing is that it's obviously important to know what you're excluding and how it's going to be construed. So please have a look at the guide. It's very important that you understand what consequential loss means according to the governing law that applies. So on to the remainder of the multi-contract specific risks. The first of these is warranty obligations. So contractors' warranties typically encompass fitness for purpose, compliance with technical specifications, which are usually very detailed, environmental and other regulatory standards, and performance criteria. Where there are multiple standards which apply, there is an inherent risk that you will not be complying with all of those standards. Some of them may be conflicting. And there's an English Supreme Court case that I refer to in my paper, Hogard, which is a matter that was exactly about this. It was an obligation that was buried away in the contract, and the court still found that that was an obligation that existed, notwithstanding that it didn't have prominence in the contract. So it's important to make sure you review all documents and understand what your obligations are. The particular issue with this disaggregated approach is that warranty obligations will not necessarily be back-to-back. And that is very much what you would see on an onshore full EPC wrap project. So if on a typical power plant you have a EPC contractor who is subcontracting with the turbine supplier, they will make sure that the warranty for that turbine is the warranty that they have to provide upstream to the owner. So you've got the back-to-back protection. But what I am seeing, what's being reported on in the offshore space, is that you don't necessarily have back-to-back warranty obligations. So what does that mean for you? It might be positive. It might be that you have a limited warranty obligation and it's good for you or your client. But it may mean that you have limited protection from the party that is supplying you something, and you have to warrant your work, which incorporates goods or material, to the owner or developer. And if you have a more extensive warranty obligation, then you will be on the hook, but you won't be able to pursue the smaller supplier when something goes wrong. So it's very important when negotiating this patchwork of contracts that I've talked about to make sure that there is consistency. If there is not consistency, then you must be alive to that risk and seek to manage it as best as possible on the project. I've put in the discussion paper the typical periods that we're seeing from different tier one contractors or suppliers, so you can have a look at those. One thing I draw your attention to is serial defects. Serial defect protection, if you are the owner, will be very important. If something goes wrong with one component on a turbine, and it's an issue across the fleet, you want to be protected for that. But what's important is that your clause gives you serial defect protection. And the way that it's drafted, it may not do that. Just as an example on that, typically the serial defect will only be covered for a particular wind farm. So it may be that there are fleet issues across all of your wind farms, and if you have different protections under different contracts, then you may have different protections on those different wind farms. So it's really important that you review those provisions and understand what protection is being given. The last point I wanted to make on this gap is in relation to repair obligations. I have seen the significant financial consequences of having to repair offshore. It is not straightforward. It is not as easy as onshore. A specific risk or issue that you may face is that you may not be able to access vessels to assist with the offshore repair in the time required. And that is particularly the case at the moment with the supply chain issues that we are seeing. So if you find yourself in a scenario where you can't remedy the issue for a period of time because of lack of vessel availability, but you might then also find when you re-review a contract with a smaller supplier, if you're the tier one contractor, you might find that they are only obliged to repair the materials once they're back on shore. And so that means that you're on the hook for arranging the vessels, transporting, then they will do the repairs, then you take it back. That's not where the cost and risk sits. It doesn't sit with having to repair defects on shore. It sits with all of the weather risks and vessel availability risks, and having to actually obtain the components and transport them back to onshore. So you might think that you've got protection and then go and look at your subcontractor or supplier contract and realise that you don't have anywhere near the protection that you need if you're a tier one contractor. And so this really very much brings me on to the next point on this slide, which is subcontracting with suppliers. So my transactional colleagues have said that they are seeing that these contracts are not being given the due care and attention that is needed. And I think that's because there are pressures on completing negotiations promptly, but also the big contracts, the important ones, are usually seen as being the ones between the developer owner and the tier one contractors. So they get given a lot of, there's a lot of analysis, consideration, a lengthy negotiation. But if the tier one contractor is then left to their own devices to go and agree a series of contracts with their suppliers, and they're busy also doing other things in relation to delivery of the project, there may be less analysis, there may be less time that's being spent on looking at all the provisions, and sometimes I have certainly seen terms being agreed where there should have been more pushback, better negotiation, more engagement to seek to agree better terms. In some ways, it may have just been that you could propose back-to-back protection, but that hasn't been proposed because sufficient time's not being spent on these. And the comment from my transactional colleagues is that these are often an afterthought in their view, and it is important to avoid the risks that come with not looking at these contracts properly. The next point is contract revisions, incentivization to meet revised deadlines. So contracts often will fail to adequately address these interface issues or knock-on consequences, delay issues. And then when it comes to problems arising, agree subsequent arrangements or incentivization programs. But what's really important is that those agreements align with ongoing contractual obligations. They need to be recorded as formal contract amendments. They need to be treated seriously, and there needs to be a real review of what the impact is going to be, rather than trying to do a band-aid approach, which is to push everyone along but not think properly about what the consequences are. So I think that that's something that very much needs to be dealt with during the project execution phase. So the final point here is dispute resolution provisions. And I mean, this is something that people often leave the dispute resolution clause to the last minute. I know that my colleague Mino is going to be speaking to dispute resolution clauses, so I'm not going to be saying a lot about this, but I just want to flag that the disaggregated approach means that as a contractor, you may end up having multiple disputes. And that can be a real issue for cost reasons, because you might get outcomes on different arbitrations that are not consistent. But also, it's obviously, usually quite helpful to have all parties who may be the cause of loss or damage to be involved in the same arbitration. And there are consolidation provisions under the major arbitral institution rules that allow for consolidation in different ways. So sometimes it's an opt-in and sometimes it's automatic or by agreement. But what I have seen is asymmetrical consolidation agreements, where the developer or owner asks the contractors to agree that it can elect to consolidate arbitrations if it wishes to do so, but the Tier 1 contractors cannot do so. You might not be able to agree anything different, but it's something to be aware of, because it may mean that the Tier 1 contractor needs to run multiple arbitrations, which is costly and time-consuming, but that the developer owner has an advantage of being able to pull everyone into the same dispute. So look at your dispute resolution provisions carefully. Consider whether ideally they would all be same arbitral institution, and ideally same governing law across contracts, so that you have consistency as to how provisions will be interpreted. So I'd like to move now on to project risks, and these are risks that are inherent in offshore projects. And the first of these is seabed risk. Now, I think it's generally accepted that a contractor, a Tier 1 contractor, is not able to take full seabed risk, given the difficulties of obtaining a comprehensive survey. And this is a known risk. I mean, it's a risk in onshore projects. Offshore, it's magnified. Often disputes arise between actual conditions and what's referred to as rely upon data. So the thing to be aware of is that contracts will commonly only permit the contractor extra time or cost where there are unforeseeable physical conditions. So what does that mean? What it normally means is not reasonably foreseeable by an experienced contractor. And the experienced contractor will have the benefit of the rely upon data. Now, one thing that I wanted to draw to your attention on this is an English court case. There are two that I refer to in my discussion paper. But the one that I have here is in relation to what is an experienced contractor. And I think it's helpful to be aware of the fact that under English law, you can't simply point to the rely upon data and say, well, it was soft soil over there, and it was soft soil over there where these samples were taken. And so we just assumed that the seabed would be identical to the samples that were taken. That is not the position at English law, because that's not what an experienced contractor would know to be the case. Now, that's a very simplistic example that I've given, but and I'll read out to you what the court said here, but it was that every experienced contractor knows that ground investigations can only be 100% accurate in the precise location in which they're carried out. It's for an experienced contractor to fill in the gaps and take an informed decision as to what the likely conditions would be overall. So I think it's important to be aware of the fact that you can't simply point to data that's been provided and say, we've experienced something different, so it's unforeseeable. That won't necessarily be the case. Every case will turn upon its own facts, but that's just a point to be aware of. In relation to weather risk, this is very much a critical difference between onshore and offshore. I mean, you might have heavy rain occasionally on an onshore project. You might have significant storms, but mostly parties can get on with their work in the onshore space. It's very different in an offshore space. Adverse weather is likely to affect a very broad range of activities. In particular, certain vessels cannot work where you've got wave height or wind speed over specific levels. And so as soon as that happens, it's a matter of downing tools and you can't continue to progress the project. This can obviously have a significant impact on timetable. I have seen on some projects where, as a result of delay, you get pushed into different seasons where then weather risks may be more problematic because of the sorts of weather risks that come with different seasons. And so that can cause even greater problems for parties. And the other area that I see this is in relation to delay for rectification of defects. I talked a little bit about the issues with gaps in contracts, but it's also worth being aware of the fact that usually when you have to repair a defect, it is, I'll say an emergency situation, but it's not planned. Often it's not planned. And so I had a court case a couple of years ago that was in relation to a HVDC cable, and it was damaged while some works were being undertaken on the beach. And now it ran out to sea, and there was repair work that needed to be done onshore and offshore. And you probably know the HVDC cable, although this was an interconnector, it's the same cabling that's used on offshore wind projects. And the party that we had on the other side was very surprised at the costs that we were seeking to recover from them because they thought that they were astronomical. We were successful in recovering the costs of repair because we were able to have experts who demonstrated that these are the sorts of costs on projects. When you do unexpected work, you have to mobilize very quickly. All of these sorts of things can lead to costs being very high for repair of defects. So that is a significant risk that thought needs to be given to, and often you'll have in place contracts that have an underlying framework with people who can carry out repairs, and then you do a call-off so that you have someone lined up. You don't have to go through the tender process to make sure that you've got the right experts to carry out defects repairs. So there's a range of things that you need to do in order to remedy that issue. On to design risk, and I think the key thing I just want to say here is that obviously offshore wind is continually developing. We see turbines getting bigger and bigger, and we see that wind farms are going further and further out to sea. Although at the moment, floating offshore wind only makes up a very small part of implemented gigawatts, it's here to stay, and that carries with it risks in those projects. The quote I have here is from the National Renewable Energy Laboratory, which is, I believe, a US government energy department sponsored lab, which undertook an assessment of risk. And I thought that these words in red, there's a typo there, but I'll read it to you. It's meant to be uncertainties permeate every aspect of the physical modelling and statistical data. And really what comes away from that report is that there is design risk in all aspects of offshore wind. So I would just say you need to be alive to that. I'd be very careful about agreeing to any proven design obligations, given how new many of the designs are. And just be aware of where design risk can hit. So a direct impact on turbine loads, material behaviour and strength if there's new material being used. Site suitability and due diligence was identified as being a key area of risk when you're designing a wind farm. And then there's a couple of others up there. Well, I think computational modelling, which is heavily relied upon in order to assess feasibility of a wind farm. This report identified real risks with the modelling process that's carried out. So, I mean, it's a bit... There are lots of risks in the design space. I think it's just good to be aware of those. If you have the time, there's the paper that I've referred to is quite lengthy, but it is cited in my discussion paper, and you can have a read of that. So I just want to move on to, I need to cover supply chain just for a couple of minutes, and then I'll move on to disputes avoidance strategies. I talked earlier about the sorts of targets that we are seeing and the fact that actually we're nowhere near building out at the rate that we need to. So last year was 8.8 gigawatts implemented offshore. We need to be doing 70 gigawatts a year to meet targets. There are not enough vessels. There are not enough workers who are experienced, skilled workers who can do this sort of work. And I highlighted some of the issues with materials. So China is implementing huge numbers incredibly quickly, but they're taking a very protectionist approach. They are making sure that they have access to the minerals that they need. They have their own OEMs who are providing turbines. But what we're also seeing is this security of supply risk and concern by countries who are concerned about allowing China to supply to them. So I think it's the single greatest risk for offshore wind farms moving ahead at the rate proposed. But it's also a risk because it means that there's a volatility in the price of materials. And if you have agreed to provide or supply something and you haven't locked in your own costs, then there's the potential that your profit on a project will be eroded, a real potential for that. And I refer to, in my discussion paper, a study that was carried out by, it's in relation to the Baltic Seas, but it was very much, it identifies that there are not going to be enough vessels within a couple of years, and that there needs to be action from government, from vessel suppliers. There needs to be real buy-in. I think it's the biggest risk, and I'm not seeing the implementation that is needed. So moving on to disputes avoidance strategies, these might seem obvious, but the number of times I see parties not following these sorts of strategies means I think that they're worth covering. So the first is to know your contract. I think once you've entered into your contract, identify the risks. We're often asked now, I'm often asked to come and sit with a client and review the suite of contracts and to do that risk analysis for them. But in-house lawyers are eminently capable of doing that, and project teams need to rely upon their in-house lawyers, their legal department, to help them with that. Knowing your counterparties is important. I've seen, I'm speaking here about onshore and offshore projects, but I've seen projects where there's a working relationship. If it's a Korean company working with another Korean company, they may have worked quite a lot together historically. There's trust. That may be very different to someone that you haven't worked with before who takes a protectionist approach in delivering what they need to deliver under the contract. So that's part of your risk assessment, is knowing your counterparty. Knowing your risks is creating a risk matrix of the risks from the contracts, the counterparties, the risks that are specific to the project, and they will be different on every project. And so it's identifying what those are so that you know how to manage them, so you can develop a plan. And also investing in your team. I think it's really important to make sure that you have the right people, skilled workers, and also that you have a legal team that you're interacting with. And then the final thing I just want to say is in relation to evidence. I can't move on without just making a point about this. In the onshore space, there's always a risk that witnesses will move on, documents will be lost, the ability to go and assess risks will be lost with time. But that risk is minor in comparison to the offshore position. An example of that is the dispute I was telling you about, the HVDC cable dispute. We had experts on the ground 2 days after the incident occurred. They were taking photographs, they were assessing issues, and they subsequently provided reports which could report upon what happened at the time. All of that evidence was lost. I mean, it's a beach, so whatever happened with equipment being there and damage to the cable, that all gets covered over with sand and you can't see it anymore. You will have the same issues further offshore. So it's really important to act quickly. For experts, I think that there are an increasingly smaller number of experts in niche areas. So we needed an expert on the HVDC cable and repair methods, and we found it hard to find someone. And he was grey-haired, shall I say. So we're not looking at a big pool of people, some who are young and some who are older. We had a pretty limited pool to select from. You will see that going forward. Witnesses of fact, they move on to other projects, they move away, they may move out of the sector. So it's important to identify who knows what at the time. Witnesses' memories are fallible. People will not remember things accurately 3 or 4 years later. It's important to remember that. And documentary evidence is king. So record keeping is so important. There's more to say on that in the sense that you shouldn't be going out and obtaining a report that includes information that could be prejudicial to your position because it could be produced later in the arbitration. But you do need to document the facts so that you have a record of those. Tribunals refer to contemporaneous documents and prefer them over witness testimony. And so that's just an important point to make. I've just got up here the resources I was talking about. So the consequential loss exclusion clause guide. We've also got a concurrent delay guide. I haven't spoken about concurrent delay today. It's in my discussion paper. It's treated differently around the world. And so if you want to see how it's treated under different jurisdictions, please take a look. But otherwise, thank you for bearing with me, speaking in English. And I think now we're going to be moving to a panel discussion with some excellent panelists. So I'll hand back over to Professor Chung.
Well, it was a very well thought out presentation. I think you may refer to the written materials she presented. She wasn't able to cover all of the points she added to the written materials. So it's quite comprehensive, well-written presentation. Well, as I heard her presentation, it sounds like daunting and intimidating. There are a couple of subjects and terms that we never experienced under the EPC contract setting, like knock-on delays, because it is a multi-contract settings. One package is delayed significantly. That is adversely affects other packages, and also the vessel's availability is very important. If the vessel is not available, and then even though the vessel is a standby right now, the weather condition does not allow, and then the vessel's owner has another plan to, utilize the vessel on the different projects in another location, then they have to move on. So that kind of situations entangled each other, then I think that it'll be very chaos in the project. So developers and contractors are very cautious to address those unexpected issues that you may encounter under the multi-contract setting. Well, we have two discussions in front of us, so let's take a seat over there. Sit here. Okay, let's move on to the discussion of this first session. Where we have two discussions, right on me, Mr. Cheo Jin, head of Korea Generation. Korea Generation is a Macquarie related entity who is a specialized entity for development of the wind power projects. He's going to discuss this speech from the developer side. And we have another lady from Samsung C&T, Ms. Kim Hyun-mi. She's a Korea licensed lawyer, and she used to work with the large law firm before she rejoining Samsung. She, first of all, she started her career with the Samsung C&T after she becoming a lawyer, and she worked with the large firm for the couple of years with a concentration of the arbitration related case. Mr. Che also is a Korea licensed attorney in law. He used to work with another large law firm beforehand, before joining the Korea Generation as the head of Korea. Okay, let's, Mr. Chet, I'll give you 10 to 15 minutes.
Yeah.
All right, thank you.
Thank you. Thank you, Sarah. It was very insightful presentations, and I was very impressed by your expertise and experience. Now I am, my job is originating and developing offshore wind projects, but 10 years ago I was also practicing Korean law at Korean law firm, but I'm not practicing anymore. I am more. I realized that I am more suited to being a developer. Not so contract is too much complicated. So my discussion may be outdated because 20 years ago I studied the law. I studied law, and then after pass the exam, I didn't study further. Just like very typical Korean lawyers back then. But when I was practicing law, my area of focus was project financing, and at the time, 10 years ago, the multi-contracting is not common at all, and nobody was talking about multi-contracting. And also the actually the market participants that didn't feel the necessity of multi-contracting back then, and there were a couple of reasons which is still apply to the couple of projects and to the developers. The first reason was that previously the PPA was given by the government at the last minute of the development, which means the REC plus S&P bundle price contract is the price is fixed at immediately before the financial close, and market was just confident that the government is going to give them a tariff, which makes the project bankable. So it was like a bilateral discussion and negotiation between the turnkey EPCI contractors and the government or public GENCO, and the price was given by way of back-solving mechanism. So the developer didn't have much passion to do the multi-contract, which was headaching. And also the second reason, which is the biggest reason for developer, is that the developer, many of Korean developers are wanting to extract the premium as quickly as possible, and they want to minimize the injecting the construction equity. Which means developers are requesting the senior lenders the higher gearing. So I witnessed for solar projects the gearing more than 95%, and the ESS project gearing was the 99%, and these days for offshore winds, still the developers' expectation on gearing is very high, more than 85% and 90%, which means the senior lenders don't have other choice but pushing the turnkey EPC contractors to wrap all the risk during the construction, and also the push the O&M operator to wrap all the risks during the operation. But however, having said that, the reason why I said earlier this discussion on multi-contract is very timely is that the market is changing. So the Korean turnkey EPCI contractors are realizing that it was too much aggressive to take all the responsibilities and liability, given there are many of new types of potential risks and challenges which cannot be reasonably forecasted. And also the on O&M side, the public GENCO does not do wrap all the liability for O&M period anymore because they have to go through the board approvals and they are subject to government audit. So now there will not be no more back-solving mechanism for the PPA. Because the government is going to introduce the tariff auction starting this year. So the contract model in Korea is becoming similar to what the market participants are doing in the UK and Europe. Secure the PPA contract as early as possible, and the developers' capabilities and expertise will be on squeezing down each packages so increase the project profitability, and also the currently the total capacity of offshore wind farm which are under operation is there are 3 projects under operation. The total capacity is 124.5 megawatt. But the developers are developing around 38 gigawatt capacity, and among 38 gigawatt, 20 gigawatt capacity of offshore wind have obtained electricity business license. And the government target is to build 14.3 gigawatt by 2030. So, which means within 7 years, the developers have to build the more than 14.2 gigawatt capacity of the projects. So, to this journey, I think obviously, the complicated permitting and consenting process is the challenging factor, but putting aside that permitting and consenting, the remaining, but the most challenging is the new type of contracting practice. And so, yeah. So, yeah, still, but the one thing just want to share with my thought, maybe the multi-contract, the large institutions are pursuing the multi-contracting strategy, which is very familiar, including Korea generations, but we have witnessed that maybe not the best choice for the small local developers because for the multi-contract strategy, the developer needs to deploy a huge team, which is more than 50 to 70 steps with experienced package managers. But the development of offshore wind projects is very risky. So the many of local developers are not able to maintain that big size of team, and also all of these days, all of the packages, including turbines and towers and foundation cables, wind turbine installation vessels, they are all the sellers market. So the many of local developers are rejected by those supply chains, so they would want to rely on tier 1 the contractors such as Samsung or Hyundai. So there is, but anyway, there is the specific concerns of the small developers with the small projects, but it is the market trend here in South Korea. The market is moving forward to the multi-contract strategy. Maybe a bit of, not a big challenge, but a small consideration is that the Korean legal system is civil law, and there are many laws which have compulsory clauses, such as a framework act of construction industries and other laws. So it is. And also the that laws and the clauses are applicable to the projects located in the Korean territory. So, for example, the contractors and the developer needs to be very careful to avoid or to make an agreement which is deviated from the Korean law, because the Korean court often tends to interpret differently, considering all the factors and the circumstantial the situation. So, so I was going to just introduce just one Supreme Court case. It was about the warranted liability. The parties agreed different terms, which was deviated from the one of the Framework Act on the construction industry, but the contractor lost the case because the Korean Supreme Court said that even though the parties had agreed on the special agreement, which was deviated from the Framework Act, still there was no evidence between the parties. The parties wanted to exclude the application of the civil code, the default liability, which was, every contractors and developers are very familiar with the FIDIC type of contractors, but there are some the landmines under the Korean law. So I think we need to be cautious about the Korean, or also the Korean legal systems and the court's interpretation. But anyway, thank you.
Well, thank you for your discussion, Mr. Choi. He just mentioned regarding the developer's perspective, whether to go into the EPC and the multiple contracts, and also he just asking about the interpretation about by the Korean court when the FIDIC standard form is applied, into the projects, and the governing law of the contract is a Korean law. I think that is that and also he just mentioned about the commercial issues that the developers is facing all the time. So do you have a response?
I have to say that, everything that you've said chimes with my experience, but the particular point you've made about the Supreme Court case that you just referred to, I have seen those sorts of issues arise around the world. And I think it's because sometimes you will have an insistence that it is local law, Korean law, but other times if you have international parties or parties that are non-Korean who have greater bargaining power, who insist upon the contract being a more neutral governing law, so they might want, for example, English law, that when you're swapping out one governing law for another, it's not a straightforward, we just change the governing law as Korean law to English law. There can be significant impacts on both how the terms are interpreted and also whether they are legal. So I talked about the mutual hold harmless regime. That's not necessarily going to be upheld under every jurisdiction. So I do think that, just a final point on that, I worked in the Middle East for a couple of years and I saw it happen there in ways that almost made me laugh as a lawyer, because you'd have a contract that would be negotiated for a long period of time with English law being the governing law, and then the day before it was signed, someone would just swap in that it would be the law of the UAE, and no further thought would be given as to whether that actually worked. And disputes would arise and parties would be surprised about this. So I think it's a really important point. I think the phrase landmines is a really apt way of describing the sorts of risks that you can face when you change out the governing law and don't think about the consequences. And I mentioned earlier that you may end up having different governing laws for the different contracts on the project, and that can also create issues.
Well, it sounds like Mr. Cho is thinking that the governing law should be in Korean law in the projects here in Korea, and then Sarah is just reiterating that the governing law might want to be English law, in order for the interpretation of the terms and conditions of the standard form of the contract, like a feeding, to be interpreted correctly by the Korean court. Ms. Kim, your turn. Given 10 to 15 minutes.
Thank you. My name is Yeonmi Kim, in-house counsel at Samsung C&T. Thank you, Sarah, for your presentation. It was very helpful to understand the risks associated with offshore wind. As many would agree, the EPC or EPCM contract has been widely used in power industry, allowing great prediction of overall price and time for completion. Perhaps this is still one of the most preferred types of contract, even in offshore wind, for developers. However, in typical EPC projects, the contractor is responsible for the whole project execution and fitness for purpose of the results. Essentially, the contractor takes almost all risks related to the design, procurement, and construction. The contractor perhaps would not have much difficulty in taking such risks and promising the owner that they would complete the project satisfying the owner's requirements without undue delay. However, Sarah and Mr. Choi pointed out this may be different in the offshore wind project with elements of new technology and offshore construction. Although there are a few contractors with offshore wind project experience, the history of offshore wind project is still short, and the size of the projects completed so far is relatively smaller than that of the traditional power projects. In light of this, it may require more project records for contractors to follow traditional EPC allocation in a comfortable way, and some adjustment to the traditional EPC risk allocation might be necessary, and that perhaps was the reason why a multi-contract scheme has introduced. This observation leads to a question that what kind of risk makes the contractor being reluctant to adapt to the traditional EPC risk allocation, or what kind of risk should the contractor keep an eye on in executing the EPC contract? I guess the answer to this question may give us some guidance in drafting multi-contract. Sarah has suggested common contracting risks, which I fully agree with, and among them, one of the risks that the parties should keep an eye on would be design-related issues, and I'd like to add a few more details on that. For the purpose of discussion, I'd like to introduce a hypothetical scenario as to design errors. Suppose the contractor's design was based on long-standing codes and standards widely used in the industry, and during construction, an error was found in the codes, and it requires redesign and rework of certain parts of the work. In this case, who should be responsible for such redesign and rework? Well, under the traditional EPC risk allocation, the contractor would bear such risks of redesign and rework, and it may not be a problem for the contractor to take such risks, at least at the time of the contract, because they knew it would be very unlikely to happen from their experiences and expertise. However, I'm not sure if this would be the same in the offshore project. The technology of offshore wind farm is rapidly evolving, and it has yet to be adequately and sufficiently tested and verified. Furthermore, the data, including weather, wind, or wave condition at the site available for design, may be outdated and insufficient, thus unreliable. This inevitably leads to various design problems and design changes, and the parties need to take caution when drafting design liability clause. To ease the strict design liability, one of the options that the parties can consider is using a reasonable skill and care obligation. This obligation can generally be satisfied if the contractor used a standard that other competent professionals in a similar position would have done so. This allows the contractor to claim that it used reasonable skill and care that other competent professionals would have used, and for this reason, they cannot be held liable if they have done so. However, on a related note, it may be worth noting that the contractor's such argument that they have used reasonable skill and care and they're free would not work if there is a fitness for purpose clause in some jurisdictions like England. Well, perhaps Korean courts, based on civil law jurisdiction, would have less strict approach than that. But still, I guess it will try to distinguish between reasonable skill and care obligation and fitness for purpose clause. A fitness for purpose clause in England makes the contractor's design liability more onerous, even being an absolute warranty obligation. As many of you would already be aware, a famous case rendered by English court in 2017 dealt with this issue. The contract in question contains both fitness for purpose clause and reasonable skill and care obligations. In this case, the court found that a fitness for purpose obligation is binding and it requires a high standard of performance, even where a reasonable skill and care obligation is agreed upon. And also the court found that the contractor should be liable despite the fact that the design failure was due to an error in long-standing codes and standards rather than design flaw by the contractor, which is the same as the hypothetical situation mentioned earlier. Considering this, it is recommended to take extra care over the use of generic clause of fitness for purpose. And the contractor should be aware that they may be construed as taking an absolute design liability in accepting such obligation. And Sarah just has mentioned the back-to-back scheme to the subcontractor or suppliers might not work in the offshore wind world. Since I have a few more minutes, I feel somewhat obligated to make one more remarks. Please do not consider this one is less important than the earlier one. There would be contractors who are willing to take turnkey risks in offshore project. And one of the options that they can consider would be forming a consortium with other contractors or equipment suppliers as a way to distribute the risks among themselves. The consortium agreement in the construction world refers to a case where the members agree to perform a separate and distinct part or scope of work and only be liable for such specific scope or part of work among themselves, being still jointly and severally liable to the owner. This may effectively reduce the risk. It would be definitely very helpful to have a clear liability cuts. However, the interface and knock-on effect issue may not easily go away. Delays in offshore wind power, which involves offshore construction with a limited of working days that the contractor can actually work due to weather, wave conditions, availability of vessels, would be inherently complicated. And even the scope of work is clearly defined under the consortium agreement. When it comes to distribution of liability, it would be very difficult to analyze and prove the impact of the delay itself and who the responsible party is and how much it should be responsible. Well, despite the challenges that offshore wind projects have faced, thanks to various contracting precedents in traditional power projects, at least the contractors are able to grasp the challenges that lie ahead. There is a saying that the known risks are manageable, hence no risks. And I guess these challenges will be an opportunity for those who are prepared and ready to manage. In this sense, the question to us at the end of the day would be how to handle and manage the risk wisely. Thank you.
Response?
Yes, thank you. I have to say I'm very happy that you picked up on design risk. I don't think I was able to spend enough time on that, but it seems to me that that is a key area of risk for parties. You talked about standards not always being sufficient if they are satisfied, if you also have a fitness for purpose obligation. I think that's very true. I've also seen obligations where parties need to comply with standards even where they're evolving, which doesn't seem unreasonable, but in practice that can be very onerous. And if you think about the fact that if you've planned for your package of works based upon certain standards and there is recognition that they're no longer right and there's a change, how does that actually impact the project? Could end up being quite a significant question. So I think it's important to really have an understanding of what you've committed to. And so if you are just having to comply with to be a reasonable and prudent contractor or comply with certain standards and that's it, then that is, I think, far less onerous than a fitness for purpose obligation. And the Hogard case is one that probably struck fear into a lot of contractors because typically we don't see a short document of this sort of length setting out what the technical specifications are. They are normally numerous schedules, and then you have a very lengthy contract, and then you've got other practices that you need to comply with, and in some contracts you have to comply with standard practices, and that will be defined. So the obligations really can be quite extensive, so it's really important to be aware of those. Just one other point you made on that is the site and seabed survey risk and the risks that entailed in that. That was something in particular that was picked up on in the report on that I referred to in design. It was that actually not enough time and money is being spent on assessing the seabed risk and site conditions, and that is a real area of risk as a result. And so if you, I think there was a kind of best practice approach is that more is done in that space in order to better understand those risks so that wind farms are not facing the sorts of risks that we've been discussing. In relation to your other key point in relation to the approach that contractors take and the consortium approach, I do think that there has to be a different way forward in relation to contracting. And so I think it's very much watch this space and see what happens. I am less close to that than my transactional colleagues, but you do hear talk about whether something along the lines of contract alliancing would work. It hasn't worked fabulously in some jurisdictions where that's been brought in as an idea as to how to get these sorts of risky and expensive projects over the line. But I do think that it's inevitable if you have lots of parties and lots of contracts that parties will take a protectionist approach. I think that's understandable, but it's not the best thing for a project in order to get parties to all pull in the same direction. So really insightful comments from my perspective. Thank you.
Well, thank you for your response. Well, I think that that kind of interpretations might be different depending upon which governing law is being applicable to the construction contract. Sarah has just replied based upon the English law interpretation over the fitness for a particular purpose requirement. But if the governing law of the construction contract is being Korean law, then slightly different interpretation might be interpolated in that situation. Well, I think Mr. Choi just mentioned a bit. Small local developers hesitating to accept a multiple contract setting, which means the small local developers would prefer EPC contract setting. Is that right to understand?
So the small local developers wants to do the multi-contract, but the supply chains are very arrogant and they have no bargaining power. So they have to rely on the big names such as Hyundai, Samsung, or Daewoo. Otherwise, all of the supply chain I have witnessed in the Korean supply chains, given the supply and demand, our company have to convince them our projects is moving forward in a timely manner. And also the supply chains are asking reservation fees, yard and the turbine. So that is not the thing the small local developers are capable of handling. So they wanted to do the multi-contract in the first place, but they concluded with relying on the big name turnkey EPC contractors.
Okay. Just want to make sure that what other bigger developers would you like to prefer? We have many developers in this room, so I just wanted to make sure that multiple contract structures are mostly preferred than the EPC contract setting, or the EPC contract structure is preferred. Mr. Moon? Or what about RWE? RWE is the second largest developers worldwide. Do you prefer multiple contract structure or the EPC contract?
Well, obviously we are, we originate from Germany and typically favoring contract.
Multi-contract setting. Any other developers who prefer the going with the EPC contract setting? No one? Then the multiple contract structures might be prevalent in Korea. So RWE just go with the multiple contract, and then the Ørsted, I think, will going with the multiple contract, which those companies are developing the giga size of the projects in Korean Peninsula, and the local small local developers may need power to go in there. So I think we need to go further, explore the more options and what would happen if you have a multiple contract setting. And as Sarah mentioned, there are many difficulties and issues that need to be taken into consideration. And as I just mentioned earlier, it's quite intimidating. I cannot picture all of those things. How can you just put all of things together into the separate contracts? So in order for all of those contracts to be consistent each other. Otherwise, if one contractors are delayed, and they will be adversely affecting the kind of knock-on delays, and then exacerbating all of the projects in jeopardy. So I think that one of the proper option we can think of is to prepare standard construction contract. The standard contract packages for the multi-contract structures in Korea. Sarah just presented her own paper. What the Phoenix Yellow Book is used for the multi-contract structure overseas, but developers are having the substantial deviation from the Phoenix Yellow Book, because the Phoenix Yellow Book is made based upon the onshore project, not for the offshore. And also another standard form is a logic. If you look at the page 4 of the written materials, and you can find out the brief explanation about the FIDIC and logic and BIMCO NEC. I recently ordered the standard form of the logic for my own personal research and study. Logic is used widely in the oil and gas projects. It is designed for the offshore projects. But I think, do you know what's the feature of the logic? Is it adaptable to the offshore wind?
It's not being used extensively in my experience. It is FIDIC, Yellow and Silver Book, heavily amended that's being used. I've listed out those other ones because they are ones that we see, but at the moment there is no standard form for offshore wind, and there has been I've seen discussions about whether money should be spent, as you've just raised, about developing standard forms, but that money money has not been spent and time taken to achieve that. And so I think where we are at the moment is that we have essentially bespoke contracts across the sector that are being used. I think that will change to some extent as more parties have more experience. So simply as an example, I would expect at some point that developers would, decide upon the sorts of clauses that they are happy with, that are the preferred clauses, and then what they might be willing to agree. You see those sorts of things for oil and gas contracts, and they'll have, internal books as to what can be agreed between parties. I just don't think that there has been the same period of time that's been spent negotiating contracts in the offshore wind space, and so that's why we haven't seen that yet. But I do think it will change.
What about the NEC?
NEC is another, so I've seen that being used for some projects, but it's very much where, for example, the UK government is involved and they have familiarity with it. I've spoken to Japanese contractors who've had it presented to them where there is a UK party involved, but it's not something that is used. It's actually a contract that is, there is more of an approach where seeking to have all parties pulling in the same direction and to share in the reward and the risk. But that's not what I'm seeing on international projects. It's really just a heavily amended FIDIC or bespoke contracts.
Okay. Well, it is my understanding that FIDIC and logics are kind of a confrontational basis. It is like a protectionist approach taken by the FIDIC and then the logics drafters. Otherwise, on the other hand, NEC 4 is the recent version. NEC is presenting the cooperative manner among all of the stakeholders in the single project. There's an early warning obligation is imposed upon all of the contractors if either one finds that the significant delay of the projects will be incurred. So give an early warning to get all of the parties together to just to find out the possible solution to minimize the possible delays. But the NEC is not designed to be used for the project finance setting. I think that the project finance will be raised by the developers to fund a significant amount of capital, but the lenders does not like this kind of cooperative manner contract, because the lender would like to pass all of the risk down onto the lower level of the suppliers and contractors, rather than the project companies taking over that risk. So I think that either one, no standard form of the contract that are currently available is not suitable for the offshore wind project, so that the developers are making the substantial deviation and then just passing all of the risk down to the lower suppliers and contractors. I don't think that will be successful. The lower level of the suppliers and contractors do not have a capacity to tackle all of the risk and then the challenges, and then they also have a limited amount of the cap in the liability. So even though the lower level of the contractor and suppliers will be liable for any substantial delay and then the substantial amount of the additional cost, the developers will not be able to impose all of the liability on the lower level of the contractors and suppliers. So I think that the better way it will be like this. Korean developers, the local developers and the international developers and Korean contractors would like to create a Korean style of the standard form of contracts, considering the multi-contract structures will be proceeded in Korean projects. I think that will be much better to minimize any possible risk, and then the increase more likelihood of success of the project. That's what I think. What is your thoughts, Sarah, and then two discussions?
I think if time and money was able to be spent on that, it may be something that's picked up by the market. I think the challenge is that if you've got, for example, oil and gas players who are coming into the market to participate in renewables projects, and they have the bargaining power. If they're not happy with the standard form that's being presented to them, they won't use it. And increasingly, my oil and gas transactional colleagues who are now doing more renewables work are saying that that's what's happening, that oil and gas companies or traditional oil and gas companies will come in and say, this is how we contract on an oil and gas project, take it or leave it, and they have the power to demand that. So I think it's certainly, I think it's a great idea to be a country that's is developing a suite of contracts that can be used, but in reality it will depend upon whether that suite of contracts is palatable and picked up and becomes popular and then becomes used as to whether that would succeed.
Yeah. Just one thing top of my head is I always like the cooperative contract model, collaborative, because when I was a lawyer, I used to say, sorry for inappropriate language, but I said the contract should be the piece of toilet paper, because when you open the contract, which means the parties are in troubles and the relevant case handler, the staff are ready to be fired. So the contract shouldn't be the tool for finger pointing, but try to find the not amicable, but the collaborative solutions, because especially the offshore wind project, from the survey to the installation packages to the completion of the construction, all of the parties' sincere effort to deliver the project will be very necessary. And these days, what I have witnessed, experience with the low-tier supply chain have the very rare expertise, and we are finding difficulties to procure the proper supply chain company. So we always said we always pursue the win-win solution. So the contract should be accommodating this mindset.
Any additional contribution from Ms. Kim?
Well, as far as lenders are happy about it and allow us to use it, yes, I think it's a great idea to have the standard contract capturing unique characteristics of offshore wind projects.
Yeah. Oh, well, I think we can just spot the very good structure and terms and conditions, unique terms and conditions from each of the FIDIC and Logic and NEC, put them all together, then make them all of the stakeholders will be beneficial. Then I think that the lender might be happy about that. I think we can do so. Let's try to do that. All right. It's past almost 20 minutes over. We allocated the first session. I think I would like to take your questions, but we have another Q&A followed by the second session. So please keep your questions and comments and then just give us. I will happy to take that your question at the time. Okay, let's take a break for 20 minutes. Just refreshments and coffee and fruit outside, and then reconvene at 4:20. Thank you.
그 이슈들을 한 3가지 정도를 들고 나왔거든요. 그래서 그것들을 좀 약간 그 독특한 이슈면서 최근에 이제 굉장히 대두되는 좀 약간 트렌디한 이슈이기 때문에 그게 한 뭐 9페이지, 10페이지, 11페이지 나오고 그게 좀 포인트고요. 나머지 것들은 좀 편안하게 보시면 될 것 같아요. 이미 그 한국에서 오프쇼어 윈팜 프로젝트가 앞으로 뭐 2023년도 또는 그 이후에도 더 활발해질 거라는 점은 뭐 설명을 안 드려도 잘 아시기 때문에 교수님이 그 생략 권유를 압축 권유를 하셔서 이 부분은 그냥 보시면 될 것 같습니다. 마찬가지로 그 한국은 여러 가지 이제 아까 중국 얘기를 해서 저는 너무나 흥미로웠는데요. 저는 이제 주로 그 디벨로퍼 자문보다는 지금은 그 밑에 스틸 스트럭처 서플라이어 자문에서 많이 하고 있거든요. 그래서 상대방이 RWE 오스테드 뭐인 경우가 있는데 그래서 strong capabilities in steel도 그 steel structure, 그다음에 shipbuilding and cables, 그다음에 그 또 전체적으로 마켓 컴페티티브니스 때문에 한국에서 오프쇼어 윈팜 프로젝트가 굉장히 뜨겁다. 그것도 보시면 될 것 같습니다. 그렇기 때문에 이제 한국 정부 차원에서 그 해상풍력 발전을 조금 더 그 증진시키기 위해서 여러 가지 정책들을 펼치고 있고요. 또 그 여러 가지 해외 자본들을 이제 유치하면서 formation of foreign domestic partnership is generally recommended and expected. 그러니까 joint development agreement라는 게 나올 수밖에 없는 게 여러 가지 그 강점이나 특징을 가진 예를 들어서 펀딩을 담당하는 쪽, 그다음에 또 규제를 담당하는 쪽, 그다음에 또 시공 쪽 노하우가 많은 쪽이 이제 같이 모여서 디벨롭먼트 컴퍼니를 세우는데 그 디벨롭먼트 컴퍼니를 세우기 전에 야 우리 다 같이 잘 한번 해보자 해서 그 전 단계로 이제 체결하는 게 조인트 디벨롭먼트 어그리먼트고 많은 경우에 그게 이제 동일하진 않지만 상당히 이제 겹치는 내용으로 쉐어드 어그리먼트로 들어가거든요. 그러면 이제 디벨롭먼트 컴퍼니를 세운 다음에 각 주주 간 나는 이 역할, 너는 저 역할, 우리 같이 이익 나면 나눠 갖자. 이렇게 이제 되는 겁니다. 이게 혼자서 뭐 개발 사업 많이 해보셔서 알겠지만 혼자서 되는 게 아니라 여러 이제 그 이해관계자들이 모여서 조인 디벨롭먼트를 하게 되죠. 그러다 보니까 아까 이제 시공자 레벨에서는 컨소시엄 얘기도 나왔고, 그다음에 디벨로퍼 레벨에서는 조인 벤처, 또 궁극적으로는 그게 회사 형태로 인코퍼레이트 되는 조인 벤처 컴퍼니 형태를 많이 사용합니다. 그게 이제 라이어빌리티 차원에서 훨씬 더 유리하다라고 봐서 그렇게 보는 거거든요. 그래서 이 조인 디벨롭먼트 어그리먼트에 대한 얘기를 조금 이따 더 말씀을 드리겠습니다. 그 다음에 이제 또 한 가지 특징은 굉장히 기간이 길다는 거예요. Long-term investments with high upfront capital costs. 그러다 보니까 이게 나중에 발생할 수 있는 어떤 기후에 대한 리스크나 시공 리스크를 초반에 모두 다 예상하기가 힘들다는 거죠. 그에 비해서 굉장히 프로큐어먼트 쪽에 비용이 많이 들고요. 저는 사실은 그 17년도에 아까 그 영국 대법원에서 선고한 MT 호가드 판결은 저는 개인적으로는 조금 과하다라고 생각을 하는 게 사실 fit for purpose라는 게 그 목적이라는 게 그 계약에서 말하는 목적이 그 구석탱이에 있는 것까지 다 봤을 거라는 걸 전제해서 이거는 의무의 범위에 포함시키는 거야 라고 하는 건데 사실 변호사가 검토하는 그 커머셜한 계약 부분과 그래서 거기서 리스크를 스파팅하는 거랑 저기 테크니컬 스페시피케이션 구석탱이에 있는 디자인 라이프 20년이라는 거를 제가 봤을 때 변호사가 그거 검토해가지고 스파팅을 못했을 것 같거든요. 거기까지 검토하라고 저도 그 검토 요청 그렇게 받진 않아서 그랬는데 그 리스크를 그 어스움하고 그거를 언더테이크 했다라고 보는 게 저는 좀 도식적이라고 보는데 그냥 저 혼자만의 생각입니다. 여하튼 영국 대법원 저는 조금 수정이 필요하지 않나라는 생각이 들고요. 아까 이제 김 변호사님이 코드가 틀렸을 때 코드대로 했는데 근데 코드가 뭔가 틀렸을 때 그것도 목적적 합성 의무 위반으로 볼 거냐. 글쎄요. 코드도 그게 결국 코드대로 건설을 하는 게 그 계약의 목적이면 어떻게 그 코드까지 다 베리파이를 해야 된다라고 볼 수 있는지 그거에 대한 베리피케이션 의무 조항이 있으면 모를까. 그거 없는 상태에서는 그건 좀 아무리 fit for purpose라고 해도 그거를 약간 무슨 엑스 마키나라고 하는 거 완전 무슨 그 검처럼 사용하는 거는 좀 과하지 않나라는 생각을 했습니다. 어쨌든 그런 특징이 있기 때문에 이 MT 호가드 판결도 해상풍력 프로젝트였고요. 그 다음에 굉장히 레귤레터리한 리스크들, 또 폴리티컬 리스크들이 많이 내재되어 있는 부분인데 타리프랑 관련된 거랑 아까 밀접하게 연결되어 있어서 아까 최 변호사님도 말씀하셨지만 그래서 이 해상풍력 또 아니면 태양광 쪽으로 투자자 중재가 굉장히 많이 발생하는 게 국가에서 타리프를 바꿔버리면 투자자 입장에서 내가 믿고 들어갔는데 내가 약속받은 거랑 다르잖아. 그러면 나라에서 책임져야 해서 투자자 중재가 굉장히 많이 제기되는 게 태양광, 그 다음에 해상풍력은 아직까지 그렇게 많이 보이진 않는데 많아질 것으로 생각되는데 또 이슈 유형이 다르진 않기 때문에요. 또 테크놀로지가 신규 테크놀로지가 많다라는 거 아까 얘기를 했고 또 그리드 인티그레이션 이슈도 상당히 해상풍력 발전의 특징이다. 또 넘어가겠습니다. 조인트 디벨롭먼트 어그리먼트가 이제 쉐어홀더스 어그리먼트 체결 전에 다 같이 우리 한번 잘해보자. 그리고 조인트 벤처 컴퍼니를 다 같이 설립해보자 라는 내용이 담기는 경우가 많거든요. 그래서 거기서 나는 이 역할, 너는 저 역할, 나는 요거 하고, 언제까지 뭐 하고, 그런 roles and responsibilities가 이제 기재되어 있는 게 일반적이고요. 파이낸싱은 어떻게 할 건지, 또 매니지먼트는 어떻게 할 건지, 또 디시전 메이킹은 어떻게 할 건지, 이게 다 끝나고 나서 청사는 어떻게 할 건지에 대한 게 가장 이제 흔한 JV 계약과 뭐 다를 바 없이 조인트 디벨롭먼트 어그리먼트도 그런 내용들이 들어갑니다. 그래서 뭐 이거는 제너럴하게 각자 하기로 한 거를 안 했을 때 브리치 오브 컨트랙트를 문제를 삼는다든지 아니면 나중에 쉐어홀더스 어그리먼트 단계에서 주주가 뭔가 문제를 제기해서 회사가 손해를 봤다. 그러면 다른 주주가 회사를 대신해서 마치 이제 파생하는 또는 데리베티브하게 주주 대표 소송을 제기해서 회사를 이제 통해서 다른 주주한테 야 회사 손해 맺거나 라고 하는 그런 주주 대표 소송이라든지 아니면 청산 단계에서의 와인딩 업 클레임이라든지 또 요거는 이제 한국 법상으로는 있지는 않은데요. 마이너리티 JV 파트너가 다른 이제 메조리티 JV 파트너를 상대로 내가 너무 부당하게 피해를 입고 있기 때문에 그 피해를 보전해달라라는 unfair prejudice 클레임이 인정되는 국가도 있다고 합니다. 한국 법상으로는 없고요. 요게 이제 9번 슬라이드, 10번 슬라이드, 11번 슬라이드가 최근에 JV 어그리먼트에서 많이 보는 유형의 이슈여서 제가 이제 한번 소개해드리고 싶었던 건데요. 민법 조항이 또 제가 코드를 잘못했더라고요. 703조인데 한국에는 특이하게 이거는 이제 옛날 독일에서 마을에서 다 같이 으쌰으쌰해서 같이 공동으로 투자해서 공동으로 이익을 누리자 하는 조합이라는 정정하겠습니다. 조합 이슈는 한국 특유의 제도입니다. 그래서 공동으로 2인 이상이 공동으로 출자를 해서 공동으로 이익을 받는 그 형태면 이게 회사가 아니더라도 다 같이 이제 조합이라고 이제 부르거든요. 근데 자세히 보면 이 JV 계약이나 아니면 조인트 디벨롭먼트 어그리먼트도 사실은 알맹이가 너무 조합이랑 비슷한 거예요. 2인 이상이 모여서 같이 출자를 해서 같이 뭔가 일을 해서 다 같이 잘 되면 이익을 나눠 갖고 안 되면 같이 로스를 감수하는. 그래서 이거 누가 봐도 조합인데 그러면 한국 민법상 특히 이제 계약의 준거법이 한국법인 경우에 한국 민법상 조합에 관한 규정이 적용될 수 있는 거 아니야? 라는 게 이제 여러 분쟁에서 이슈가 된 적이 있거든요. 뭐가 다르냐? 이게 조합 규정이 적용되냐 안 되냐에 따라서 조합 규정에는 선량한 관리자의 의무, 위임 규정에 있는 그 위임 계약에 있는 선량한 관리자의 의무를 준용하고 있어요. 그래서 조합원들끼리도 특별히 계약서에 우리가 너를 위해서 내가 선량한 관리자로서 의무를 다 해야지 써있지 않더라도 이미 민법에 선관주의 의무가 있는 거예요. 그러니까 뭔가 그러면 계약서에 안 쓰여 있어도 얘 펀딩 담당하기로 내가 리파이낸싱을 담당해야 된다라고 명시는 안 돼 있지만 이거 선량한 관리자라면 이거 해야 되는 거 아니야? 이거 안 했으면 이거 계약 위반한 거 아니야? 라든지 그 계약서에 있지도 않은데 선관주의 의무를 끌어들여서 이거는 계약 위반 아니야 라고 해서 클레임화 시키는 그 건들이 단건이 아니고 상당히 여러 건들이 최근에 있었습니다. 이게 그 해상 그 풍력 발전 맥락에서 그랬던 건 아니고 여러 가지 이제 그 조인트 디벨롭먼트 어그리먼트에서 파생된 건데 사실 해상 풍력 발전을 위한 조인트 디벨롭먼트 어그리먼트에도 이게 동일하게 적용되지 말라는 법이었거든요. 그럼 이제 되게 난감한 거죠. 그러면 계약의 준거법을 한국법으로 할 경우에 항상 이 문제에 직면하게 되는 건가? 내가 그러면 조합이랑 이 민법에 있는 조합 규정이랑 내가 원치 않는 이 선관주의 의무나 이런 거 불분명하거나 이런 거 싫은데 그러면 무조건 영국법으로 가야 되는 건가? 이제 라는 의문이 들 수 있는데 아직 클리어컷하게 이 부분에 대해서 뭐 정답이 있는 건 아닙니다. 근데 저희가 이제 어드바이스를 드린 거는 아예 조인트 디벨롭먼트 어그리먼트에 명시를 해라. 이거는 조합 관계가 아니다라는 거를. 그러니까 웃긴 게 조인트 디벨롭먼트 어그리먼트랑 쉐어드 어그리먼트랑 내용이 똑같다 보니까 주주들은 사실 회사의 주주들은 서로 무슨 의무가 없거든요. 그냥 주식 하나 사고 그걸로 땡이에요. 그게 사실 주식회사의 그 뷰티이기도 하고 그냥 주주가 주식 사서 그거 에퀴티 사면 그냥 그만큼의 책임지고 땡. 그게 이제 회사의 컨셉인데 요거는 독특하게 전 단계에서 같은 내용의 조인트 디벨롭먼트 어그리먼트가 있다 보니까 이것도 조합 계약이고 심지어 쉐어드 어그리먼트도 약간 조합 성질의 그런 의무가 있는 거 아니야? 이제 이런 그 주장들이 제기되는 걸 저희가 여러 건 이제 방어하는 쪽에 있었는데 그래서 팁은 조합 관계가 아니다라는 거를 명시하는 게 좋겠다. 비슷한 맥락에서 한국법 이거는 이제 영미법계 변호사님들이 특히 영국법 변호사님들이 상당히 그 경계하는 컨셉 중 하나가 신의성실의 원칙. 거의 약간 이제 경기를 일으키죠. 영국 변호사들은 굿페이스 하면 굉장히 무슨 그 악의 어떤 그 계약의 그 명료성이나 확정성을 해치는 어떤 악마라고 생각하는데 실은 그 한국법상 신의칙이 그렇지는 않습니다. 굉장히 구체적인 유형과 구체적인 요건별로 적용되는 국면이 한정되어 있기 때문에 그렇게 이렇게 무한정 신의칙만 한 스푼 가미하면 이게 무한정 의무가 확대된다든지 없던 의무가 생긴다든지 그런 건 아니긴 합니다. 근데 그래도 어쨌든 주장하는 측면에서는 뭐 조합관계가 아니라고 하더라도 그래도 한국법상 신의칙, 신성실의 원칙이 적용되지 않냐. 민법 2조에 떡하니 그게 대원칙으로 있지 않냐. 그런데 이게 계약서에 써있진 않지만 응당 조인트 디벨로퍼로서 또는 뭐 주주로서는 조금 뭐 그보다 덜하지만 조인트 디벨로퍼로서 신의성실하게 이 정도는 했었어야 되는 거 아니냐. 근데 이걸 안 했으면 이거는 계약 위반으로서 손해를 배상해라. 라고 이게 또 클레임화되는 경우가 있습니다. 이거는 아까 조합보다도 더 난감한 게 그 신의성실의 원칙은 적용되지 않는다라고 계약서에 적용해도 그게 효력이 없거든요. 워낙 강행적으로 인정되는 대원칙이기 때문에. 그래서 이제 저희가 실무적으로 드리는 팁은 뭐냐면 계약서 자체를 조금 그 러프하거나 좀 루즈하게 남겨두지 말고 의무와 권리 사항들을 구체적으로 최대한 다 그 레이아웃을 해라. 그래서 신의칙이 스며들어갈 틈을 뭐 없애진 못하더라도 그거를 최소화시키는 게 좋겠다. 그럼에도 불구하고 그 뭐 신의칙이 항상 이제 문제가 여전히 되죠. 그 대법원 판례들도 최근에 나오고 하는데 그렇지만 최대한 계약서를 구체적으로 그 권리 의무 사항들을 정리하라라고 저희는 어드바이스를 합니다. 요런 이슈들이 있을 수 있다는 거, 한국법이 중국법일 때. 또 세 번째 이슈로는, 이거는 회사 설립 이후에 아까 말씀드린 것처럼 주주가 다른 주주를 상대로 회사가 입은 손해를 청구를 못 하거든요. 그 영미법에서는 이걸 reflective loss라고 해서 회사가 입은 손해는 주주 입장에서는 반사적 손해에 불과하기 때문에 이거는 주주 고유의 손해가 아니고 회사가 청구할 수 있을 뿐이다. 그래서 주주 대표 소송을 제기하면 모를까, 한 주주가 다른 주주한테 이걸 청구 못한다라는 이제 reflective loss principle이 이건 손해 유형으로서 청구 불가한 손해로 취급을 하고 있고요. 한국 법상으로는 이게 그만큼 클리어컷하진 않습니다. 판례들이 그렇게 클리어컷하진 않은데, 일반적으로는 그 회사가 입은 손해는 주주 입장에서는 간접 손해를 보기 때문에 이 부분은 다이렉트리 청구하는 것은 어렵다라고 비슷하게 보고 있어요. 그래서 이거는 그 법을 바꾸지는 못하고 그와 같은 유형의 손해들을 청구할 수 있는 주주 대표 소송, 데리베티브 클레임이나 아니면 불법행위가 인정되면 불법행위 청구를 통해서 다른 수단을 통해서 클레임 제기하는 방법들을 조금 창의적으로 모색할 필요 있다. 이렇게 이제 좀 많이 나오는, 여러 분쟁에서 거듭해서 많이 나오는 이슈들 세 가지를 소개해드리려고 했고요. 그 외에는 이제 첫 번째 시간에 얘기했었던 테크니컬 이슈스라는 게 법적인 관점에서 말을 이제 치환하자면 목적 적합성 의무랑 연결된 것 같아요. 기술적인 부분은 얼마나 리스크 언더테이킹을 할 거냐. 특히나 기술이 계속 바뀌고 있는데 이거를 목적을 어디까지로 볼 거냐. 그 이슈가 여전히 영국에서도 그게 완전히 정돈된지는 잘 모르겠어요. 목적의 범위가 어디까지인지. 어쨌든 현재로서는 MT 호가드가 이제 가장 표준적인 판례여서 기술적인 스펙 구석탱이에 있는 것까지도 목적의 일부다라고 이제 보는 게 영국 판례 입장이긴 한데, 하여튼 그게 계속 유지가 될 수 있을지는 잘 모르겠습니다. 그 다음에 아까 거듭 세라가 얘기했었던 seabed 리스크, 웨더 리스크들도 종종 나오는 테크니컬 이슈랑 연결된 기후적인 리스크고요. 딜레이 관련해서 이제 시공자가 발주자 또는 디벨로퍼를 상대로 EOT 청구를 한 경우 말고 이미 LD는 부과가 됐어요. 이미 지연이 돼서 디벨로퍼가 컨소시엄을 상대로 LD를 부과를 했습니다. 그래서 컨소시엄에서 한쪽에서 다 냈든 아니면 뭐 분담해서 냈든 일단 냈고, 그 다음에 내부 정산한 그런 사건이 몇 년 전에 있었거든요. 근데 사실 같은 컨소시엄에서 이제 일을 하다 보면 그때는 내 탓, 니 탓 그걸 생각 안 하기 때문에 이게 내가 내 부분 언제까지 잘했고 이거를 사실 레코드 키핑이 잘 안 됐거든요. 그러다 보니까 거기서 이게 딜레이에 대한 내부적인 어포션먼트를 하는데 굉장히 애로사항이 있었습니다. 그래서 아까 제가 봤을 때 이건 문화적인 차이일 수도 있을 것 같은데, 이 영미계 또는 유럽계에서 문서로 많이 남기는 문화와 그게 크게 공격적으로 느껴지지 않는 문화와 레터를 보내거나 아니면 뭔가 문서화 시키는 게 나 못 믿는 거야? 아까 회의 때 다 얘기했잖아. 뭘 또 이거 이메일 또 같은 걸 회의록을 왜 돌리고 난리야? 라는 문화권이나 문화적인 차이가 좀 있는 것 같은데, 어찌됐건 제가 프로젝트 사이트에 있지는 않았어서 뭐라고 이렇게 딱 잘라서 말씀드리긴 그런데, 하여튼 컨소시엄 내부적으로 딜레이를 어퍼션하는 데 있어서 레코드의 부족으로 상당히 애로사항을 겪은 사건 한 5년 전에 하나 있었습니다. 요거는 제가 말씀드린 규제적인 이슈가 많기 때문에 국가를 상대로 투자자 중재를 제기한 건들이 일부 이제 제기가 됐고, 주로 태양광 분야에서 스페인을 상대로 수십 건들이 투자자 중재 건들이 있는데, 오프쇼어 윈팜 프로젝트에서도 크게 다를 이유가 없다라고 보고요. 그래서 이게 투자자 입장에서, 해외 특히 이제 아웃바운드 투자자 입장에서 그 나라의 규제가 전혀 예상치 못하게 바뀐 경우에 하나의 구제 수단으로서 진지하게 고려해 볼 필요가 있다 해서 그냥 소개 차원에서 갖고 왔습니다. 이제 15년 이하는 그 중재 PR인데요. 사실 소송으로 분쟁을 해결한다라고 계약서에 잘 넣지는 않는 것 같아요. 드문 것 같고, 어차피 중재를 넣는 경우가 많은데, 특히나 이제 국적의 다른 당사자가 있는 경우에는 중재인을 내가 선택할 수 있다는 거, 또 대리인이 그 나라 그 변호사 자격이 있는 변호사가 아니어도 내가 대리를 할 수 있다는 거, 라는 게 이제 크고, 그 다음에 특히 언어적인 부분도 그래도 영어가 이제 표준적인 중재 언어로 사용된다는 거, 그런 이점 때문에 거의 중재로 가는 것 같습니다. 한 가지 더 이제 중재의 그 장점으로서 잘 생각이 안 되는 부분이 뭐냐면, 문서 송달 이슈에 있어서 중재가 메리트가 있습니다. 소송은 헤이그 협약이라고 그 소장을 제출하고 나서 수개월 동안 다른 나라에 송달될 때까지 엄청 오래 걸리거든요. 중재는 바로 중재 신청서를 이메일로 띡 보내면 바로 송달이 되기 때문에 그 신청서를 송달하는 그 이슈, 그 다음에 중재 판정 집행, 뭐 그 얘기는 많이 하지만 하여튼 그 Service of Documents에서 이점이 있다는 걸 잘 생각 안 하는데, 그게 소송으로 가면 그게 세월아 내월하거든요. 그래서 그런 측면에서 중재의 장점이 이런 부분도 있다. 그 다음에 이제 confidentiality 얘기를 하고, 또 duration of the proceedings 얘기를 하는데, 두 가지 모두 뭐 사실 저는 세모라고 생각합니다. 하늘 아래 비밀은 없다고, 결국은 또 confidentiality가 그 지켜져야 하는 게 원칙이긴 한데, 어떻게 또 그 중재 전문 잡지에서 기가 막히게 또 알아내더라고요. 그래서 뭐 confidentiality는 그 원칙적인 장점으로 생각하시면 될 것 같고요. cost efficiency도 말이 많은데, 뭐 1심, 2심, 3심 가는 것보다는 시간과 비용 면에서 싸지 않냐. 뭐 그렇게 보려면 그렇게 볼 수 있을 것 같고요. 중재도 하여튼 유저들 측면에서는 너무나 그 변호사 비용이 많이 들기 때문에 cost efficient 하다는 거는 동의 못 한다라는 그 피드백을 많이 받기 때문에, 이 그 오프쇼어 윈팜 프로젝트에서 DAB나 DAAB 같은 그런 약간 그 간이한 분쟁 해결 형태가 앞으로 많아질지는 잘 모르겠어요. 그런 약간 완충된 것들이 나올 수 있지 않을까라는 생각 좀 해봤습니다. 한국에서 중재를 한다는 거, 내지는 그 한국을 중재지로 선택한다는 거, 이 장점이 뭐냐? 일단은 한국의 법 체계가 굉장히 중재 프렌들리하고요. 그 얘기인즉슨 그 중재 판정 집행에 있어서 그 시원시원하게 해주는 편입니다. 약간 그 법원에서 좀 그 우리가 중재 판정 집행을 제대로 안 해주면 너무 우리 후진국으로 비춰지는 거 아니야라는 컴플렉스가 있나 싶을 정도로 중재 판정 집행을 잘 해주기 때문에, 그리고 중재법도 굉장히 그 선진화되어 있는 운시트라 모델법을 받아들였기 때문에 다른 어느 나라에 비해서도 그 법제가 탄탄하고 사법 체계가 서포트가 탄탄하다. 두 번째로는 만약에 한국에서 진행하는 프로젝트인데 법원의 도움을 받을 필요가 있다. 실무에서는 많지는 않습니다만 중재 과정에서도 법원이 증거 수집이나 아니면 문서 수집을 도와줘야 되는 경우가 있거든요. 그럼 아무래도 한국 법원에서 그거를 한국에 있는 증인이나 한국에 있는 문서에 대해서 명령을 내리는 게 용이하지, 싱가포르 법원에서 하는 것보다는 이게 한국 법원이 에비던스 컬렉팅 도와주는 역할에서도 용이하다라고 생각이 되는데, 실무에서는 그렇게 많이 활용되지는 않습니다. 두 번째로는 그 프로젝트가 발생하는 그 이제 진행되는 그 국가에서 여러 가지 규제적 이슈들이 있는데, 그 규제적 이슈들을 그 충돌 없이, 아까 이제 건설산업기본법도 말씀하셨는데, 충돌 없이 좀 조화롭게 그 프로젝트를 진행하기 위해서는 중고법 자체를 한국법으로 하는 게 조금 그래도 그런 면에서 충돌이 적다라고 저희는 보고 있고요. 물론 아까 조합 이슈, 뭐 신의성실 이슈 있긴 합니다만, 그런 걸 감안하더라도 규제적 이슈와 그 다음에 뭐 건설산업기본법 여러 가지 프레임워크 이슈랑 융화되는 것으로서 한국법이 중국법이 되는 경우가 무난한 경우가 많고, 그랬을 때 이제 위의 꼭지가 그 한국을 중재지로 하는, 그러니까 중국법과 중재지를 한국으로 하는 그걸 싱킹하는 게 그래도 뭔가 예상치 못한 어떤 그 돌발 변수가 발생하는 거를 최소화하는 데 있어서 도움이 된다라고 저희는 보고 있습니다. 마지막으로 이제 조인더 컨솔리데이션 얘기가 아까 첫 번째 세션에도 잠깐 짧게 나왔는데, 저는 조심스럽지만 약간은 그 견해가 약간 다른 게, 아까 그 세라가 제너럴하게 얘기하기로는 모든 컨트랙에서 조인더 프로비전이 또는 그 분쟁 해결 조항이 얼라인돼 있어야 된다. 그래야지 조인더나 컨솔리데이션이 원활하게 된다. 맞는 얘기입니다. 그 조인더 프로비전이 두 개가 어긋나면 여러 당사자들을 하나의 분쟁에 끌어들이는 걸 못하게 되겠죠. 아니면 뭐 이슈가 생기게 되고 중재판정부가 나중에 중재판정이 그 집행 가능성 우려해서 꺼린다든지 안 하려고 한 경우가 많습니다. 근데 과연 분쟁에 있어서 인플로어와 컨트랙터와 서브 컨트랙터가 다 모여가지고 그 분쟁을 하는 게 좋은 건지는 사실 저는 개인적으로는 케바케라고 생각하거든요. 왜냐하면 시공자가 인플로어를 상대로 할 수 있는 주장들이 있고 서브콘을 상대로 하는 주장들이 있고, 그러니까 예를 들어서 인플로어 너 때문에 지연됐잖아 할 때는 서브콘의 입장이 동일할 수가 있거든요. 그러면서 이제 거기서의 그 라이빌리티 관계가 정리되면 또 서브콘한테 하는 그 주장들이 좀 다를 수 있기 때문에, 이게 과연 그 조인더 프로비전이 얼라인되게 중재 합의를 얼라인시키는 것과는 별개로 실제 실무에 있어서 반드시 이 멀티 컨트랙트라고 해서 반드시 조인더만이 어떤 정답이냐에 대해서는 조금 뭐 케바케로 좀 신중하게 살펴보고, 혹시 주장에 어떤 모순되는 부분들이 전략적으로 있을 수밖에 없는 경우가 있거든요. 그거를 감안해서 전략을 정할 필요가 있다고 생각이 들어서 약간은 저는 다른 견해를 좀 피력해 봅니다. 중재기관, 아까 대한상사중재원에서도 계셨던 것 같은데 지금 안 보이네요. 중재기관은 사실 그 요새 모든 중재기관들 사이에서 약간의 그 경쟁이라고 해야 되나? 우리가 다 그 현대화된 중재 규칙을 갖고 있어. 우리도 조인더 돼. 우리도 그 컨솔리데이션 돼. 우리도 expedited procedure 돼. 우리도 뭐 emergency arbitration 돼. 라고 이제 경쟁적으로 규칙들이 다 이렇게 계속 업데이트되고 있기 때문에, 그런 면에서는 사실 어느 규칙이 좋다 안 좋다 뭐 이렇게 가릴 바는 없을 것 같고요. 다 좋고, 다만 이제 중재 기관들마다 이제 한 가지에서 약간 갈리는 게, 그 당사자 합의로 중재인 선정을 못했을 경우에 기관에서 들어와서 중재인 선정을 하거든요. 그래서 거기서 그 노하우가 조금씩 그 풀도 풀이지만 노하우가 거기서 조금씩 갈리는 경우가 덜어 있다. 그런 측면에서 중재인은 항상 당사자 합의로 선정되지 못할 수도 있으니까 조금 경험이 많은 그 중재기관, 근데 들어보신 중재기관들은 다 그 경험 많은 중재기관들이고요. 중국에는 중재기관이 260개도 넘는다고 합니다. 동네마다 다 있다 그러는데 그런 데만 피하시면 될 것 같습니다. 그 외에 이제 오늘 토픽으로는 조금 이거는 독자적인 토픽으로 한번 다뤄야 될 부분일 수도 있는데, DAB랑 그 연결된 토픽으로서 조금 더 그 비용을 절감할 수 있는 압축적인 분쟁 해결 방안으로서 미디에이션이 대두가 될 것 같고, 해상풍력 발전 분쟁도 크게 다르지 않을 것 같아요. 이게 꼭 그 중재와 미디에이션을 결합한 어떤 결합 조항이 아니더라도 중재를 제기하다가도 중간에 얼마든지 미디에이션 할 수 있거든요. 그래서 미디에이션이 이제 핫한 주제인데, 해상풍력 발전 분쟁에서도 미디에이션 얘기가 계속 대두될 것 같다. 오늘 화두만 던지고 마무리하겠습니다. 네, 고맙습니다.
예, Q&A 세션을 좀 갖도록 하겠습니다. 아까 지금 퍼스트 세션에 대해서도 지금 많은 분들이 아직까지도 자리를 지키고 계신다는 얘기는 궁금한 사항들이 상당히 많으실 거라고 생각이 들고요. 그리고 이제 중재 관련된 지금 조인트 디벨롭먼트 어그리먼트나 지금 아마 이제 JDA를 하기 위해서 서로 간에 파트너들을 찾고 있는 이런 단계라고 좀 많이 들었습니다. 그리고 이제 여야 할 것 없이 이제 조금 우리 인허가 절차를지, 그 다음에 주민 수용성이랄지 이런 부분들에 있어서 조금 신속하게 하기 위해서 여권, 야권에 이제 국회의원들이 뭐 관련 법안들을 발의를 해서 그것들이 이제 올해 안에 통과가 된다고 한다면은 아마 사업 개발하는 기간들이 상당한 기간으로 단축이 될 거다. 뭐 이렇게 예상이 되는 것 같고요. 그렇다고 한다면은 뭐 조만간에 또 건설 계약에 대한 그런 부분들도 계약을 체결하면서 또 프로젝트 컴퍼니도 설립을 하게 되면서 조인트 쉐어홀더 어그리먼트도 체결하고 이제 수많은 계약서들, 프로젝트 다큐멘트들과 파이낸스 다큐멘트들을 체결을 하시게 될 거고 그 과정에서 이제 분쟁 해결 조항에 대한 부분들을 상당히 조금 많이 간과하시는 경향이 있습니다. 그래서 분쟁 해결 조항에 대한 부분들이 지금 이제 어떻게 보면은 인바운드 글로벌 트랜잭션이라는 것이 대한민국에서 지금 이루어지고 있는 상황이잖아요. 그것도 어마어마하게 큰 프로젝트의 숫자들과 딜들이 이루어지고 있는 상태이기 때문에 여기 이제 사업을 한국에서 개발하시는 또 외국계 회사들 디벨로퍼뿐만 아니라 한국계 뭐 디벨로퍼들도 있고요. 또 그다음에 컨트랙터들도 다양하게 지금 보니까 뭐 컨스트럭션 컴퍼니뿐만 아니라 뭐 케이블 또 뭐 그 여러 여타의 또 터바인 관련된 그쪽에 지금 컨트랙터들 회사들도 지금 많이 와 계신 걸로 지금 알고 있고 그렇습니다. 그래서 이 중재 조항과 관련된 그 부분에 대해서 한번 조금 생각을 하시면 좋겠다 해서 한국어로 조금 넣게 됐는데 일단 두 번째 세션에서는 토론자가 없어가지고 제가 지금 한 변호사님께 한 가지 조금 아까 중재지를 서울로 한국어로 하는 것과 중거법을 싱크로 하는 게 유의미하다 이거를 이제 말씀을 하셨는데 뭐 저도 이제 거기에는 동의를 하고요. 근데 이제 거기에 쓰신 것 중에는 그 enforcement place하고의 싱크로는 설명을 좀 안 하신 것 같아가지고 어떤가요? 여기 그 19페이지 19번째 슬라이드에서 thinking arbitrary with the place of enforcement와 관련돼서는 뭐 어떻게 지금 설명할 수 있습니까? 그에 대한 한국을 갖다가 중재지로 하는 거에 있어서 만약에 중재 절차에서 승소한 당사자가 집행을 한국에서 한다라고 했을 경우에 어떤
그러니까 결국 중재 판정 집행 리스크는 그 법원에서 보기에 해당 중재 판정이 거기에 그 공공 질서에 반하는지 여부를 보게 되거든요. 다른 어떤 그 중재 절차에서 위반 그거는 뭐 지금 논의할 필요 없는 거고 그 공소 형석에 공공 질서에 반하는지. 근데 뭐 그게 반드시 한국법을 중국법으로 한다고 해서 뭐 준수가 되는 건 아닌데 아무래도 그게 다른 나라 변호사가 들어와서 다른 나라 법을 그 중국법으로 내면서 그 컨셉으로 이렇게 계약서를 디자인하는 거랑 한국 변호사 또는 그거에 대한 너리지가 있는 사람이 와서 한국 법을 그 중국법으로 내면서 우리가 요 한국에서 통용되는 한국 판례에서 통용되는 공공질서가 뭔지를 아는 거랑 이제 최종 중재 판정 집행 단계에선 그래도 조금 그 리스크가 완화되지 않나라는 그런 차원에서 넣습니다.
예. 그리고 이제 여기 개발사이드에 계신 분들은 중재 조항에 대해서 익숙하지 않으신 분들 상당히 많이 있으실 거고 그래서 중재 기관은 이제 대표적으로 ICC, 그 다음에 CIAC, 뭐 홍콩 HKIC, 이제 우리나라 KCAB 이 정도를 아마 우리가 대표적으로 생각을 해볼 수가 있습니다. 근데 그 기관들 물론 뭐 대한산업중재원이라고 하는 KCAB를 쓸 수도 있지만 뭐 저도 ICC 중재인들 좀 경험을 해보니까 ICC가 상당히 조금 뭐 카운슬들이 상당히 효과적이긴 합니다. 아주 효율성이 뭐 대단히 높고요. 그리고 케이스에 대해서 상당히 조금 백업을 아주 잘하는 뭐 중재인 입장에 상당히 조금 편하게 사건이 진행이 될 수 있는 뭐 좀 근데 이제 ICC 중재 비용이 KCA보다는 좀 상당히 조금은 높다. 중재인 수당이나 중재 기관에 내는 그런 비용들이 좀 높다라는 거고 뭐 CIAC은 이제 그 중간이지만 문제는 CIAC 같은 경우에는 요새 케이스가 너무 많아요. 엄청나게 많다 보니까 사무국에서 제대로 핸들을 못 하고 있습니다. 그래서 저는 CIAC은 한국에서 이루어지는 프로젝트에서는 뭐 추천하고 싶지는 않고요. 그래서 ICC를 하면서 중재지를 서울로 하는 거 내지는 KCAB가 이제 비용적인 측면에서 어느 정도 효율성이 있다 보니까 KCAB 서울로 하는 것도 추천을 해드리고 근데 이제 문제가 또 컨선이 되시는 부분들은 중재인들은 그럼 어떻게 하느냐. 중재인에 있어서는 이제 당사자들이 3인 중재를 하는 경우에는 각 당사자가 선임을 하는데 RCC 같은 경우는 풀이 없습니다. 중재인 풀이. 그러니까 누구라도 선임을 할 수 있어요. 이 해상풍력에 관련돼서 엑스퍼티즈가 있는 뭐 외국 중재인들, 저명한 중재인들을 선임을 할 수 있고요. 뭐 옵니다. 그 사람들. 뭐 한국의 중재지가 되고 여기서 중재 심리가 벌어진다 하더라도 언제든지 올 수 있는 사람들 엄청나게 많고요. 그렇기 때문에 뭐 한국 회사들이 해외로 나와가지고는 그렇게 중재 절차에서 엄청나게 많이 시달리고 당했는데 한국에서 프로젝트가 이루어지는 상황에서는 한국을 좀 중재지로 조금 선호를 하는 것도 디벨로퍼 사이드에서 상당히 생각할 필요가 있어요. 특히 이제 외국 디벨로퍼 입장에서는 한국에서는 불리한 거 아니냐고 생각을 하는데 결국에는 중재인 선임을 어떻게 하느냐가 제일 중요한 부분이고 하기 때문에 또 외국 당사자가 승소했을 경우에도 중재지가 여기라고 한다면은 한국 법원을 통해서 좀 더 쉽게 뭐 외국 가서 또 집행하는 게 아니니까 집행적인 측면에서도 뭐 유리한 요소는 있지 않을까라고 생각이 듭니다. 그리고 한국이 상당히 중재 선진국이에요. 국제 중재 선진국이기 때문에 그런 부분들은 우려하시지 않을 거라고 좀 생각이 들고. 자, 그러면은 이제 첫 번째 세션에 대해서도 질문이 있으시면은 손을 들고 질문해 주시고 소속을 좀 밝히시고요. 영어로 하셔도 되고 아니면 한국어로 하셔도 됩니다. 제가 한번 뭐 좀 통역을 한번 뭐 좀 열심히 한번 해보겠습니다. 네, 질문이나 코멘트. 왜 이렇게 샤이 하세요? 예.
첫째는 이 프로젝트가 유럽이 아니라 한국에서 진행이 되기 때문에 가장 중요한 게 이제 프로젝트 파이낸싱인데 유럽 같으면은 그쪽의 금융기관들이 멀티 컨트랙팅에 대해서 굉장히 호의적이고 경험이 많아서 쉽게 수용을 할 수 있을 거는 같지만 한국은 대부분의 금융사들이 싱글 리스폰시빌리티를 선호해서 EPC 컨트랙터한테 모든 완공 증명, 완공 책임을 지으려고 그러고 있거든요. 그런 측면에서 보면은 이제 한국에서 멀티 컨트랙팅을 한다고 그럴 때 스테이크홀더들 간의 이 컨센서스가 이루어지는 게 쉽지 않을 것 같다 하는 이런 우려가 있고요. 해결 방안이 어떤 것들이 있는지 궁금하고, 두 번째는 이제 멀티 컨트랙팅에 대해서도 PD 옐로북을 heavily modify 한다고 돼 있는데, heavily modify 하지 않는다고 해도 PD 컨트랙을 한국에서 적용하려면 그 자체로 이미 heavily modify 해야 돼요. heavily modify 해야 되는 거를 또 멀티 컨트랙팅 간에 리스크 어포션먼트를 어떻게 할 것인가. 내 지분이 10%도 안 되는데 딜레이 라이빌리티를 100% 줄 수는 없는 거고, 그러면 그거를 해결할 수 있는 게 리스크 어포션먼트를 해야 되는데 그거 가지고도 부족하고, 그러면 뭐 소셜라이제이션을 해야 되느냐. 그래서 이런 것들에 대해서는 지금 한국에서 해상풍력 발전 개발 단지들이 굉장히 많기 때문에 많은 스테이크홀더들과 컨트랙터들이 고민을 할 것 같아요. 그래서 아까 정 교수님 말씀하신 대로 어떤 풍력산업협회라든가 어디가 주도가 돼서 한국형 해상풍력 발전 프로젝트의 표준 계약서를 만드는 것이 여러 가지로 좋을 것 같은데, 그거에 대해서 의견을 좀 들어보고 싶습니다. 네.
일단 지금 사라한테 질문을 드리시는 겁니까? 첫 번째는 예. Well, Sarah, he has a questions regarding the EPC versus multi-contract structures. As you know, that the Korean developers and contractors are very accustomed with the EPC contract setting, which is imposing the single responsibility on the contractor, so that the sole contractor or the joint venture of the sole contractors are taking over all of the liability and responsibilities over the project. But the multi-contract structures now is proposed by you and the other developers. But in order to have the multi-contract structures, all of the stakeholders must have go through the consensus process to agree each other among themselves. But he believes it might be difficult to reach into the consensus of the multi-contract structure. Do you have any idea to resolve that issue?
Yeah, I think it comes about in a slightly different way, so maybe it would help for me to explain that. I think that if a developer or owner is developing a project, they will say to a turbine manufacturer, can you please supply the turbines on this project, and seek to agree that contract with them. And then for the other major components, a similar process will take place. So there is not an opportunity for all parties to say, I would like this to be EPC full wrap or otherwise. What ends up happening is the example I've given, the turbine supplier will decide whether or not they want to take that contract. And the reality is, given that the disaggregated approach is now common, that if you want to work in this space, I think you would have to agree that or decide not to do this type of work. I guess that there's the potential for an EPC contractor to say, I will take on the full EPC wrap risk, but that's not what we're seeing happening. So actually, it is it's a function of the way that the contracts work, that the owner will set the scene for how the contracts are going to be negotiated. Perhaps if you have, if you have a domestic project and there is a discussion between all parties, maybe it would be possible to do it differently. But that's not what I'm not seeing that happening. So it's just not happening in that way.
Question. Just to add, to clarify the question, I think originated from lenders in this region being unfamiliar, sort of, or even reluctant to funding projects that are based on a multi-contract. How to convince them, sort of from a lender perspective?
I guess the question I'd have for those who are more familiar with the Korean market is how that is playing out, because often the tone is set by lenders, but the problem is that if lenders are saying, we're not familiar with this method of contracting, we'd prefer for there to be full EPC wrap. If you don't have an EPC contractor who's willing to do that, then the project's not going to go ahead, in my view. So there has to be either maybe greater familiarity on the parts of lenders to understand how these projects are taking place elsewhere in the world, or they're not going to move ahead unless you can find an EPC contractor who's willing to take that risk. So I think it's a bit of a game changer in the sense that projects won't get off the ground unless you can either get an EPC contractor who's comfortable with that, which seems unlikely given the current state of play, or banks or lenders recognise that the way that these projects are proceeding is different from the standard approach for onshore projects and perhaps smaller domestic projects and how they've historically been contracting. And Mino, thank you for clarifying.
예, 어느 정도 쌀의 답변은 듣긴 했는데요. 참 이런 폼에서 하는 게 좀 약간 익숙하지 않긴 한데, 일단은 제가 생각할 때는 비즈니스를 할 의지가 있느냐 없느냐일 것 같고요. 디벨로퍼가 멀티 컨트랙으로 가겠다라고 잡고 각각의 어떤 컨트랙터하고의 협상을 벌이면서 이렇게 몰고 가는 상황에서는 결국에 컨트랙터, 특히 이제 건설사 같은 경우에는 그거에 대해서 take all, nothing의 상황이 되지 않을까 싶은데요. 그래서 멀티 컨트랙으로 가면은 가는 거고 아니면은 실은 많은 그런 상황이 되는데, 근데 지금 편전무님께서는 만약에 그러면은 멀티 컨트랙트 할 건설사가 하나도 없다. 그렇게 되면 문제가 생긴다는 그런 말씀이세요?
그게 아니고
네.
렌더들하고 디벨로퍼 간에 합의가 이루어지지 않을 것 같다는 걱정이 되는 거예요. 한국의 렌더들은 시공사한테 모든 책임을 지우는 거에 익숙해져 있기 때문에 이거를 분리해서 멀티 컨트랙트로 간다고 그랬을 때 렌더들이 방향 거부감을 표현할 수가 있다 이거죠. 근데 그거를 설득할 수 있는 이런 방안이 있냐 이거예요.
다른 나라에서 지금 이미 멀티 컨트랙트로 이루어진 북유럽 같은 경우에는 이제 거기서 PF가 이루어졌을 거 아니에요. 근데 PF가 이루어졌고 그 얘기는 이제 그 디벨로퍼들이 멀티 컨트랙트로 하는 거에 어느 정도는 전문성이 있고 경험이 있고
그렇죠.
예, 그러니까
제가 이제 드리고 싶은 얘기는 그거예요. 유럽의 디벨로퍼들은 이미 그 프로젝트를 최적의 금액으로 최단 기간에 딜리버리 한 경험들이 많기 때문에 그 EPC한테 모든 그 비싼 금액을 다 줘서 비싸게 그 시공을 하느니 자기들이 직접 매니징하면서 멀티 컨트랙팅을 해서 그 개발비도 줄이고 그 공기도 단축시킬 수 있다. 그런 자신감에서 시작을 한 거거든요.
예.
그러니까 유럽의 렌더들도 거기에 이미 익숙해져가지고 그걸 호응을 하는데 한국에서 이루어지는 프로젝트에서 외국의 렌더들이 얼마나 많이 들어올지는 모르지만 대부분 한국의 렌더들이 그 주도적으로 해야 될 것 같아요. 그럼 한국 렌더들이 그걸 프로젝트 리스크, 프로젝트 파이낸싱에 대한 이런 스타디서부터 새로 하면서 리스크 어로케이션하고 뭐 그 이 프로젝트 디벨롭 하는데 관련된 리스크들을 다 해칭할 수 있는 자신이 있느냐. 그게 없으면 쉽게 그 호응을 안 할 거다 이거죠.
그 부분은 아주 새로운 어떤 포인트 같은데요. 그러니까 지금 요지는 한국에서의 프로젝트들은 한국의 랜더들이 주로 많이 인발브를 하게 될 거고 코리안 여기에 있는 한국의 랜더들 같은 경우에는 이제 EPC에 익숙해 있고 거기에서 어느 정도 랜더가 컴포터블한 그런 상황인데 멀티 컨트랙트라 하는 부분들을 새롭게 해가지고 해야 되느냐 이 부분은 뭐 쌀가 대답할 수 있는 그런 부분은 아닌 것 같고요. 디벨로퍼 사이드에 한번 여쭤볼게요. 예, 디벨로퍼에서 말씀을 해주시면 될 것 같습니다. 문 대표님도 한번 좀 말씀해 주시죠. 예, 맞습니다. 마이크 좀. 여기 한 10개는 들어와 있죠 지금 일단은.
이제 한국에 뭐 경험 있는 멀티 컨트랙 경험 있는 개발사들이 많으니까 해칭하는 방법도 있을 텐데요. 저희가 보기에는 만약에 항공 프로젝트를 하는데 지금 편집장님 말씀하신 것도 사실 일리가 있거든요. 한국 개발사 입장에서는 당연히 멀티 컨트랙을 갈 때 선호하지 않죠. 지금도 한국에서 소규모 뭐 150메가와트 정도, 한 100메가 미만의 해상풍력 프로젝트는 국내 EPC사를 턴키 베이스로 선정해서 진행하거든요. 왜냐하면 사업주가 자신이 없으니까. 그런데 외국사들은 이미 다양한 사업 개발 경험이 있고 멀티 컨트랙을 매니징해본 경험이 있으니까 그거를 국내 랜더가 수용을 이제 저희가 할 거라고 보는데 또 하나 또 중요한 포인트가 있냐면 뭐냐면 해외 개발사들은 대부분 코퍼레이트 밸런스 그 펀딩을 많이 해요. 그러니까 프로젝트 파이낸싱의 포션이 한국에서 소위 얘기하는 2대 8이 아니고 뭐 5대 5가 될 수도 있고 그러니까 랜더 입장에서는 뭐 상당히 리스크가 많이 주는 상황이고 에쿼티에 대한 그런 그 본인들의 어떤 랜더의 포션이 많이 줄기 때문에 그에 대한 리스크가 해칭이 되고 또 그 사업주의 컨소시엄이 됐든 아니면 리딩 컴퍼니가 됐든 외국사 멀티 컨트랙을 뭐 한 10개씩 수행해본 그런 회사들이 있다고 하면 한국 금융사들, 랜더들도 상당히 컴포터블 하지 않을까 이렇게 생각을 하고 있습니다. 최 대표님도 한마디.
네.
턴키를 계속 턴키 풀 랩핑을 요구하는 이유는 랜더가 선순위가 깨질까봐 걱정해서 그런 거거든요. 그래서 기어링을 지금 뭐 90% 이렇게 잡아놓으면 당연히 턴키를 요구를 할 수밖에 없을 거고 인터내셔널 랜더들도 마찬가지로 그런 조건에서는 풀 랩핑 턴키를 요구할 수밖에 없을 겁니다. 그래서 결국 자본금의 비율이 중요할 것 같고 저희가 하는 사업도 큰 사업은 이제 멀티 컨트랙으로 가는데 작은 사업은 오히려 그 턴키가 더 효율적이고 오히려 그 가격적인 측면에서도 멀티 컨트랙이랑 크게 다르지 않은 경우도 있어서 그건 이제 디벨로퍼의 초이스고 그리고 저희가 지금 얘기하고 있는 한국의 금융기관들이 굉장히 수준이 높다고 생각을 합니다. 이해도도 높고 해외 투자 많이 하고 있고 그리고 해외에서도 저희가 해외에서 수행하는 다른 사업들에서도 한국의 금융기관이랑 생보사, 화재 이런 데서 훨씬 더 전문적인 지식을 가지고 하고 있기 때문에 만약에 뭐 한국 금융기관은 뭐 멀티 컨트랙 이해를 잘 못해가지고 어렵다고 하면 좀 사실과는 다릅니다. 저희가 아는 우리 잠재적인 랜더들은 저희 유럽계나 아니면은 다른 나라의 랜더들보다 훨씬 더 높은 수준의 전문 지식을 가지고 있기 때문에 저희가 하는 사업에서는 멀티 컨트랙 관련해서 시니어 랜더의 적절한 프로젝트 파이낸싱 조달하는 거에 대해서 전혀 문제가 없다고 생각을 하고 있습니다.
그러면은 그 국내에서의 렌더뿐만 아니라 뭐 그 인터내셔널 렌더도 뭐 들어오는 거죠. 근데
인터내셔널 렌더도 당연히 그 좋은 조건을 가지고 할 수 있다면 오는 건데, 사실 지금 이런 그 비정상적인 금융시장, 이게 아니라 이제 정상적인 금융시장 환경에서는 우리나라 금융기관이 제공하는 그 대출 조건이 훨씬 더 경쟁력이 있습니다. 그렇기 때문에 지금까지 진행됐던 신재생에너지 사업을 보시면 거의 99%가 한국 금융기관이 다 PF 대출을 했던 거기 때문에 여러 가지 강점이 많고, 그리고 실제로 이제 잠재적인 투자금이 너무 많아서 저희가 하는 해외 사업장에도 공격적으로 지금 투자를 하려고 하고 있습니다.
예. 결론은 이제 포인트는 debt and equity ratio가 뭐 8대2, 9대1이 아니라 뭐 5대5 내지는 이 정도로 하게 되면 렌더의 리스크가 줄어든다라고 하는 그 부분이고, 이제 한국의 렌더들도 상당히 뭐 sophisticated하고 그렇기 때문에 그 부분에 대해서는 뭐 크게 우려를 안 하신다, 그런 입장이고, 아주 좋은 그 질문이셨고, 두 번째 질문이 이제 이제 피딕을 이제 그 모디파이를 해서 쓰는데, 피딕 옐로우북을. 근데 이제 이거를 한국에서 어차피 쓰려면은 이게 영국법 베이스로 돼 있기 때문에 이것도 한국 법이 만약에 중국법이 된다고 한다면은 모디파이 돼야 되는 거고, 근데 거기에다가 피딕 자체는 온쇼어 프로젝트를 염두에 둔 건데, 이제 오프쇼어 하는 상황에서도 그것도 반영을 해야 되는 상황에서 이제 이게 그 다음에가 뭐였죠? 표준계약 만들자고 좋은 아이디어다. 이제 그건 제가 시간을 했으니까 그건 예, 그래서 이제 여기 발표자의 발표문을 보니까 또 이제 발표자가 인용했던 문헌들이 좀 있어요. 그래서 제가 좀 시간이 나서 조금 살펴봤는데, 여러 표준계약서들이 이제 전 세계적으로 뭐 사용이 되는 게 있는데, 어느 하나 이제 그 오프쇼어 윈드 파워 프로젝트에 이제 딱 맞는 건 없는 상황이다 보니까, 그럼 뭐 다른 데서도 물론 그걸 갖다가 상당한 정도의 디비에이션을 하긴 했겠지만, 지금 해상풍력의 프로젝트가 해외에서도 뭐 벌어지고 있지만은 그게 뭐 엄청나게 많은 지금 프로젝트가 아니기 때문에 뭐 분쟁이나 이런 부분들도 아직은 뭐 많이 이렇게 나오고 있는 상황 같지는 않을 텐데, 그런 상황에서도 이제 한국에서 뭐 만약에 이제 하게 된다 그럴 때 제 생각으로는 그러한 여러 개의 표준계약서의 내용들을 좀 조합을 하게 되면은 충분히 한국적인 상황에서 할 수 있는, 뭐 디벨로퍼 입장에서도 그렇고 컨트랙트 입장에서도 그렇고, 뭐 디벨로퍼 입장에서도 그냥 리스크만 너무 그 다운을 시키게 되면은, 뭐 다운 시켜가지고 프로젝트가 망가지게 되면은 디벨로퍼 입장에서도 안 좋을 것 같고 렌더 입장에서도 안 좋을 거라고 생각을 하거든요. 그래서 너무 이게 대립적인 뭐 제로성 관계가 아니라 이렇게 콜라보레이티브한 그런 쪽으로 조금 더 쓸 수 있는 게 이제 NEC의 어떤 그런 콜라보레이티브한 그런 게 있습니다. NEC 계약 조건에 제가 논문을 한번 쓴 적이 있어가지고 그 계약 조건을 보니까 상당히 이상적이다, 이런 생각을 했어요. 근데 이상적인데 이제 그거를 한국 회사들이 하는 해외 프로젝트에서 채택이 된 경우는 뭐 거의 한두 건 정도는 들은 것 같습니다. 근데 거의 채택이 안 되는 걸로 뭐 그런 상황이고, 또 NEC는 이제 아까 말씀드린 것처럼 PF가 사용이 되는 그런 프로젝트에서는 렌더가 원하지 않는 그런 그 표준계약 조건이다라는 그것이 단서가 달려 있거든요. 근데 이제 그 NEC의 모든 것들을 채택하는 것보다 NEC의 아주 핵심적인 그 부분만 조금 이렇게 뭐 피딕하고 그 다음에 로직하고 이렇게 섞으면은 괜찮은 표준계약 조건이 나오지 않을까, 뭐 이런 생각이 좀 들어가지고 제안을 드렸는데, 사실은 그 부분은 디벨로퍼 사이드에서 이거를 수용하느냐 마느냐의 문제일 거라고 저는 생각을 합니다. 컨트랙트가 그걸 갖다가 요구한다고 해가지고 되는 상황은 아닐 거 아니에요. 그래서 디벨로퍼 사이드에서 그런 표준계약 조건을 만약에 뭐 서로 이렇게 디벨로퍼나 컨트랙터나 뭐 터바인 서플라이어나 해가지고 이렇게 머리를 맞대고 만들어서 한국에서 적용할 수 있는 것을 만들면은 쓰겠느냐, 할 의향이 있느냐, 이건데, 이것도 결국에는 이제 디벨로퍼 사이드에 여쭤봐야 되는 상황인데, 다른 디벨로퍼 분들 뭐 말씀하실 분 계신가요? 이 부분에 대해서? 그러면 여기 두 분 또 말씀을 좀 의견을 부탁드리겠습니다. 별 의향이 없으신 것 같은데요. 아직은 조금 뭐 좀 갑작스러운 그런 제안인 것 같고요. 이 부분에 대해서는 아직 뭐 디벨로퍼 사이드는 전혀 생각을 해볼 기회가 없으셨던 것 같습니다. 그 부분은 한번 이제 좀 생각을 해보시면 어떨까 하는 생각이 들고, 협회 입장에서도 한번 그 부분은 필요한 부분이 아닐까. 네. Yeah. Well, Sarah, it is for your question, for you to the answer, to address his concern. Or if there's any severely adverse weather condition occurred on in the middle of construction over there, and then all kinds of vessels should be retreated from the site of the project, and then for the time being, the construction was not going to be moving forward. So it's kind of should be regarded as a force majeure event. If the force majeure event occurs, the developer should give time of extension to the contractor, and also in case the developer may have to provide a monetary compensation to some extent. Question is how the developer is able to reduce the possibility or deal with that situation.
So adverse weather is a big risk on projects. The first point is what does adverse weather mean? And so ordinarily what you'd see is that it's anything over certain wind speeds or over certain wave heights. So it's important that gets measured accurately. And then parties will agree who bears that risk. And so ordinarily you don't have the contractor just bearing all adverse weather risk, but there are issues where, I guess not of pure concurrency, but what happens if the contractor was already not able to work for certain reasons. So parties may agree how that's going to be dealt with, and there may also be obligations on the contractor that they have to use that time to do certain things, to progress activities on the project to the greatest extent possible. Now, I have seen contracts where parties have agreed in almost like a bar chart in a contract how adverse weather is going to be dealt with. And so if it qualifies as an event of adverse weather and the contractor is already in delay, to have a bar graph showing that and then to show who's responsible for it. But you can also obviously agree how that's going to be dealt with just in the text of the contract. But it's obviously, it will turn on each contract, and there are risks, real risks for both developers and contractors, because adverse weather is a reality of offshore projects, and parties are going to have to deal with that in delivering the project.
예, 그 질문과 관련돼서 궁금한 부분은 이제 디벨로퍼 사이드에서 한국의 현장인 상황에서의 애드버스 웨더 컨디션이 어느 정도나 발생할 것인지, 내지는 뭐 우리 한반도의 그러한 정도의 이 폴스 모저에 해당이 되는 그런 애드버스 웨더의 조건을 어느 정도나 규정을 할 것인지, 그건 결국에 이제 디벨로퍼 사이드에서 조금 고민을 해보셨을 부분이지 않을까 생각이 드는데, 어떻게 혹시 뭐 좀 검토를 해보셨나요? 그 부분은? 계약서에다 예를 들어서 뭐 애드버스 컨디션, 웨더 컨디션에 대해서 어느 정도면은 이게 폴스 모저에 해당이 되는 것으로서 볼 것이냐. 아직까지 거기는 아닙니까? 아, 베슬하고 컨트롤 안 해봤어. 그건 또 이제 베슬 그 차터 어그리먼트하고도 같이 연관되는 그런 부분일 테니까, 그 부분은 또 이제 그 베슬 차 그 저기 오너하고도 조금 협의가 돼야 되는 그런 부분일 수가 있겠네요. 어느 정도 답변이 됐습니까? 네.
그 시공자가 인터넷 것도 있으면 뭐 공변경을 해줘야 되겠죠. 그래서 그렇게 공변경을 해주면 디벨로퍼 입장에서는 금융을 가지고 그 프로젝트를 수행하는데 금융 비용이 계속 발생하고, 그 발생하는 그거를 어딘가에서 컴pen세이션을 받아야 되는데, 다른 그 정부에서 이 컨세션 어그리먼트 같은 건 정부에서 운영 기간을 일정 부분 연장시켜줘가지고 운영 수익을 통해서 이 금융 비용 손실나는 걸 커버를 하는데, 이 해상풍력에서 디벨로퍼는 어떤 식으로 이걸 커버를 하냐.
그거야 디벨로퍼의 리스크 아니겠습니까? 결국에는 디벨로퍼가 결국에는 그 터바인 서플라이 컨트랙트건 뭐 파운데이션 뭐 컨트랙트건 시빌 컨트랙트건 애드버스 웨더 컨디션을 어떻게 디파인을 해가지고 거기에서 리스크 쉐어링을 할 거냐, 디벨로퍼와 다른 컨트랙터와의 관계에 있어서. 웨더는 우리가 예측할 수가 없는 상황이고 어떤 상황이 벌어질지는 모르는 상황이니까, 결국에는 그거는 뭐 디벨로퍼의 그 리스크라고 볼 것이고, 디벨로퍼가 그 다음에 어디다 기댈 수 있는 것도 아니잖아요. 그러니까.
혹시 그 발전자회사나 뭐 반영할 수 있는 그런 건 없나요? 지금 보면은 발전사에서도 이 디벨롭의 멤버로 나중에 주인을 하는 경우가 많을 텐데.
지금 여기 국내에서 벌어지는 제가 해상풍력 사업에 있어서는 일단은 송전선하고 연결이 돼가지고 전력을 생산을 하게 되면은 S&P하고 REC를 이제 디벨로퍼는 받는 것으로 돼 있고, 그 다음에 어떤 뭐 발전자회사 내지는 한전과의 PPA나 이런 부분들은 좀 별도의 지금 이슈 아니겠습니까? 그 부분은 별도의 이슈이고요. PPA를 뭐 지금 할 수 있는 단계는 제3자 PPA라고 해가지고 그거는 이제 별도로 지금 정부에서 조금 논의 중인 그런 상황인 걸로 지금 이해를 하고 있습니다. 그러니까 또 이제 그 PPA가 아니더라도 지금 그 디벨로퍼들은 어떤 잉여 전력에 대해서는 수소를 이제 생산하는 그런 플랜트까지 염두에 둔다라고 지금 얘기를 들었습니다. 그죠? 네.
명확하지 않아서 제가 답변을 못 드렸는데요. 그 오일 앤 가스에서 이제 코노코 웨더 클로스라는 조항이 있어서 보통은 이렇게 디벨로퍼하고 컨트랙터하고 반반 이렇게 많이 하는 걸로 이렇게 돼 일반적인
어떤
아까 그 웨더 그러니까
예.
날씨 때문에 뭐 작업을 못한 거에 대한 그 귀책 사유 코노코 웨더 클로스라고 합니다.
그 로직에 들어가 있는 내용인가 보네요. 로직. 예. 그럼 컨트랙터 입장에서는 좀 억울하지 않겠어요, 근데? 에드벌스 웨더 컨디션인데 그걸 반반 한다.
Yeah. It's not a question, but some additional information about this topic. My name is Ki-tae Kim. I'm working for the Oracle Energy and Water. We seen the many practices in the upstream project in the petrochemical. There is some unforeseen condition from the project development side. So there is some scientific way to calculate some schedule total plot. So you might be familiar with total plot. So developer side invest the historical the weather condition over last 30 years like that in that region, and then they can calculate to the port analysis, the optimistic and the pessimistic and middle point, and they can make the calculation for the normal distribution and some Monte Carlo simulation like that. So after the fully simulated, both parties make some agreement for the buffer. So every project cannot be done on time always. So there needs to be some buffer for in case for some such a case. So they share the buffer. So that buffer can be some countermeasure for that kind of case, I think. Yeah.
I think that's a really important comment because you don't see something similar in onshore projects where weather's much more predictable, and so there are certainly ways of addressing it. But ultimately, if the analysis or calculations that you've talked about end up not being accurate, or the adverse weather ends up being more extreme, and I think it's been recognised that sometimes the site analysis is not sufficient in order to always assess what is needed and what the best and worst position is, that you may be in a position where a lot of that risk ends up sitting with the party that bears that risk under the contract terms.
예, 혹시 한민호 변호사님한테는 질문 없으세요? 그래요? 예, 그럼 더 이상의 다른 질문이 없으면은 이번 그 세미나 우리 한국풍력산업협회와 저희 국제건설에너지법연구회 간의 공동 학술 세미나는 이것으로 마치도록 하겠습니다. 후원해주신 그 협회에 대단히 감사하다는 말씀을 드리고요. 저희 연구에 관심 있으신 분은 뭐 저희 간사들에게 좀 얘기를 해주시면은 회원 명부에 올려서 그다음 향후 세미나를 조금 들으실 수 있도록 그렇게 하도록 하겠습니다. 다음 세미나는 그 61번째인데요. 우리가 이제 그 메이저 터빈 공급자가 터빈 공급 터빈 구매 계약 이걸 체결하는데 어떠한 부분들을 고려를 하면서 계약을 체결하는지 사실은 그 터바인 공급자 측에서 이렇게 발표를 하는 것이 저희가 60번을 넘게 했는데 한 번도 못 했는데 다음번에 지금 하기로 돼 있습니다. 그래서 많은 관심 가져주시기 바랍니다. 대단히 감사합니다.